22,
18.
and 22. I have to take instruction. Let it be after the vacation, Your Lordship.
Yeah, Mr.
A Das, Your Lordship.
On request made by Das, list after Puja.
18 and 22.
Same order, 22.
Much obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 16, Your Lordship. Lordship, in this matter, I have to seek instruction from the client whether the relief they have sought has been granted to them or not till date.
Yeah, Mr.
Hi, Ahmed.
Same order.
Obliged.
My please, Your Lordship. Lordship, here I am paying for motion matter tomorrow, my lord.
Why?
Because transfer matter, my lord, the BEO has transferred the TSR without jurisdiction, my lord, without authority, my lord.
Okay.
And another matter, my lord, I am paying on 9th of after vacation, 9th,
Not 9th, 15th.
15th.
May it please your lordship, with the consent of other side, I beg to mention item 58, my lord. In this matter, my lord, we were supposed to file an objection, but the person concerned is suffering from some neurological health issues, my lord. So, my lord, kindly be taken up after vacation, my lord.
You are paying for?
For the petitioner, writ petitioner,
Okay, and request made by Ms.
B. Bora.
You were a council for list after
Vacation,
Puja vacation. 58, isn't it?
58, my lord.
Okay, all right. Yes.
May it please, Your Lordship. Lordship, pray for listing this matter tomorrow for motion, Lordship.
Why?
The petitioner was an army personnel, Lordship. His PPO was issued, but due to some technical reason, he didn't get the pension, Lordship. For
That
15
you can
years.
come after the Puja vacation, not tomorrow. Tomorrow I have some.
My pleasure, Lordship. Lordship, I beg to mention for adjournment, Lordship, item number 27, Lordship, with the consent of other side, Lordship.
You are for
Petitioner, Lordship,
your name
P. Kolita, Lordship, on behalf of A. Paramani,
on request made on behalf of A Param.
after vacation.
List after Puja.
My lord.
May I please-
32, and for the petitioner, matter become infructuous, my lord.
Yeah, Mr.
DK Nath.
Mr. D cannot then the council for petition subject to the matter. Accordingly, this petition is disposed of as purchase.
May I please, your Lordship?
Mm.
Lordship, I am mentioning the matter non-payment of pension. That takes after vacation
Yes. 17th.
70.
It is a lordship. On last Thursday, lordship had heard two matters regarding the anomalies in the grade pay of the Assam Police Radio Organization, and lordship had directed us to submit our written arguments, and I've submitted the same today, your lordship.
Just come.
May I please, Your Lordship? Lordship, I beg to mention item number 30. I'm appearing on behalf of Mr. A.R. Shom, learned petitioner advocate. Lordship, the matter may be taken after the Puja vacations.
On request made on behalf of AR Show, then the council for petition. Yes, okay. Yeah.
Obliged.
May I please, Lordship? I beg to mention item number 48, Lordship.
Yes.
He will come up after Puja vacation, Lordship, then though he will appear in this matter. He's out of station.
You good. Endar.
And that.
On request made on behalf of Endar after vacation. Yeah.
May it please, Your Lordship, may I pray for listing of an item, Lordship, after the vacation. Matter relates to pensionary benefit.
Okay. 20 November.
May I please, your Lordship, I beg to mention 23. This matter will be not taken up after the Puja vacation.
23.
Yes,
You're appearing on behalf of
petitioner,
your good name.
S. Vishwas,
On request made by S. Who's your senior?
R. Sharma.
On the request made on your art after Puja.
May I please, your Lordship?
Obliged.
With the consent of other side, Lordship, I beg to mention item number 29, Lordship. There's some personal difficulty, Lordship, let it come after vacation. I've taken the consent of.
You've taken consent
Yes, Your Lordship.
on request made by Mr. SS.
Roy.
SS Roy.
Yes, Your Lordship.
You are the CGC.
Yes, Your Lordship.
Please start the Puja.
Obliged.
May I please, Your Lordship?
Yeah.
I beg to mention for listing one writ petition after vacation, Lordship, any date.
Yes. 17th.
70. Obliged.
Item one for motion.
May I please your lordship, my lord? Here, my lord, in the instant case, my lord, petitioner, my lord, are working as a, my lord, fixed pay employee, my lord, for the period more than 10 years, my lord. Of the 13, 14 years, they are working, my lord. And my lord, your lordship kindly come to the, my lord, page, annexer page 32, my lord, 34, annexer 2A, my lord. All the petitioner's name has been mentioned, my lord, dated 20 September 2011. The following 72 person has been engaged by daily wages laborer in the Assam Secretary for the 1520 detailed below. All the petitioner name has been mentioned in page 35, my lord, subject to correction of my friend, my lord. And my lord, your lordship kindly come to the, my lord, next page, my lord, that if your lordship go, my lord, directly, my lord, page annexer 4, page 66, my lord. This is the, my lord, concern note sheet, my lord, between the commissioner and secretary and principal secretary, my lord. Your lordship kindly come to the, my lord, last paragraph. Page 66, last paragraph. Have your lordship got it?
Yes.
Since the issue of regulation in service and issue are partly clearly distinguishable, and though they are temporary or have completed service after the date of judgment may not be entitled for regulation of service. However, they may perhaps pay minimum pay scale if they are found eligible on the basis of principle equal pay for the equal work. I am asking only this relief, my lord, because my lord, in writ appeal, my lord, this honorable court has passed an order, my lord.
This is a file noting.
I'm coming, my lord. This is the, my lord, it is a admitted position, my lord, that I am working from 2010, 2011, my lord. I am working more than, my lord, 13 years, 14 years. Our division bench judgment has categorically stated that if a person is working, my lord, same status, equal for, that benefit should be given. I have given the order of this WDHP number 45, my lord, para 22, my lord. I am giving the copy of the huh? Para 20, if you go to this order, my lord.
That will consider the matter, will issue notice.
Yes. My humble submission before your lordship, there is a similar order, my lord, following this division.
Wait,
That order,
let them first get some instructions.
yes, my lord.
Yes.
I'm only that the protection that they verify, and if they found genuine mail, they are working. The protection of writ appeal should be given only purely on law.
Lordship, in that writ appeal, which is Upenda's versus State of Assam, Lordship. In that case, Lordship, it is categorically stated regarding master rule, work search, and contextual, Lordship. Here in this case, Annexer 24, Annexer 24, page 34, 38, 42. Here in this case, the petitioners were engaged for daily wages, Lordship. It is neither categorically stated that under the master rules, work search or contextual, Lordship. Therefore, I have to take instruction regarding their feasibility of work.
Mr. NNB Chowdhury,
May I submit, my lord? One thing is, my lord.
Yes.
Before submission make, my lord, this judgment has come following the Jagjit Singh judgment, my lord.
That I know.
Jagjit Singh judgment has categorically said, my lord. Now they cannot say, we are only that casual employee, temporary employee, my lord. I am submitting before the honorable casual employee who are working continuously more than 10 years. That is the spirit of the law, my lord. Of the
That's
Jagjit
why I'm
Singh.
issuing notice.
Yes, my lord.
Issue notice.
Yes, my lord.
Who address? Respondent one.
I'm appearing. If you can respond number 1.
A Fukan standing answer.
SAD.
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 1 and 1 and 5.
1 and 5. Mr. Chalyan standing on finance or 2, 3 and 6.
I am appearing on behalf of respondent 4 personal department.
And Mr. Goswami, the additional senior government. GK Goswami. For the one number 4. Petition of complete. However, extra copy if any.
What my fixed date, my lord?
are not- I think it is what it is. 29th November.
Much obliged.
Thank you.
Item 2, my lord, Mr. SK is supposed to take instruction.
Lordship, I am
Yes.
here for restaurant number 3 on behalf of Mr. Executive. Lordship, instruction is awaited. We have not received any.
Respondent number
3.
A date may be fixed after the.
is not.
My lord.
Learned counsel for the petitioner. On request made on behalf of SK Medi, learned standing counsel accounting. This matter on,
Lordship, that may be 15 November
okay, 15th of November, to
Obliged.
enable him to receive instructions.
Obliged.
of next.
Lordship, notice has to go to respond number 6 in the private, lordship.
Let the instructions come, so after that we'll see.
My lord, in this matter, we are being led by learned senior counsel, Mr. TJ Mohanto. He is in court 1. It may be passed over for the time being. Otherwise, item numbers 3 and 10 are connected. They may be taken up together.
Where's your senior?
In court number 1, he is in legs in court number 1, my lord.
Who appears? Irrigation Department,
Irrigation. Irrigation.
Niyogi, DS Niyogi.
Item 3 and 10 connecting.
Okay, after some time.
Deep level.
Item 4.
Only this petitioners, they did not receive the error salaries for the period, my lord. Page 14, lordship, can you say?
Page
14.
yes. How many petitioners are here?
6 petitioners. My lord. And inspector of schools made a reference to the director, page 37.
Then
And again submitted another proposals, my lord, page 40.
yes, then
So my prayer is, my lord, let the director inquire the matter for the inquiry, and if we are entitled, pass appropriate order after hearing the.
My lord, notice may be issued here, my lord.
why? This is only area
This is the
salary.
financial matter, my lord.
Let the director inquire.
Yes, my lord. Director may inquire the matter.
Paragraph 3, I stated.
All in same school?
Same school, all the same school. Goripur High School. And same proposal has been made, mentioning all name of all the petitioners, my lords. Page 15 onwards.
But Mr.
Jai Ahmed.
J. Ahmed, learned counsel for the petitioner. Also heard Mr.
U. Sharma.
U. Sharma, learned
Order,
standing
number
counsel.
1, 4 and 5.
Secondary education for respondents, 1,
1, 4 and 5.
4 and 5. Finance,
Finance, I am appearing.
Mr. N. Babujari, learned standing counsel finance for respondent number 2. Accountant general,
Somebody was here.
Easy matter. Accountant.
Mr. D. Rabba. D. Rabba, learned standing counsel.
I am appearing on behalf of Mr. A. Hassan.
Appearing on behalf of Mr. A. Hassan, learned standing counsel, accountant general for respondent number 3. Stop. Para. Petitioner number 1 is still serving?
Working as Hindi teacher.
Still now?
Yes.
Para, the petition number 1 is serving as Hindi teacher at the Gauripur High School. And she's claiming her error salary for the period 29/5/1992 to 39/2003. Stop. What is the petition number 2 serving?
He is serving.
Huh?
He is serving.
As?
Yes. Serving as my lord, teacher, assistant teacher.
Are you sure?
Yes, my lord.
Hindi teacher.
The petitioner number 2 is also serving as Hindi teacher
Hindi.
of Gauripur High School. No, cancel the all the writ petitioners except petitioner number
Petition number 3.
3 are working in different capacities in the Gauripur High School. Stop. The petitioner number 3 retired as a UTA of Gauripur High School. And since then,
She expired.
he has expired. Stop. The so petitioner number 3 has expired.
Expired.
So who is representing?
His husband, my lord. Her husband.
Then you see that all except petitioner number 3, huh? Then the petitioner number 3 is the husband of late Virola Baladas, who retired as UDA of the Gauripur High School and has expired. Okay. All the petitioners are praying for their error salary with regard to different debts. Stop. But the non-roll certificate with regard to the petitioners, the non-roll certificate of error salary with regard to the petitioners was also issued by the headmistress of Gauripur Girls High School on 2012-2009. Has it been countersigned? Not countersigned.
Yes. Countersigned.
Where?
No.
Yes, it is not consensual.
Stop. No, stop. The inspector of schools, Dhupri district circle, Dhupri, also sent a proposal for release of arrear salary in respect of the 6 petitioners by a communication dated 3/1/2020 addressed to the Director of Secondary Education, Assam. Stop. Where's the other one?
Other in my lord,
By another communication dated 11/1/2022, the Inspector of Schools, Dhupri District Circle, Dhupri, submitted the proposal for release of arrear salary in respect of the petitioners to the Director of Secondary Education, Assam. Stop. The grievance of the petitioner by way of the present petition is that despite the proposal being sent to the Director of Secondary Education, Assam, no steps has been taken till then. Stop. After considering the matters available on record, this writ petition is disposed of, directing the Director of Secondary Education, Assam, respond number 4, to have a verification with regard to the arrear salary demanded by the respondent by the petitioners. And thereafter, if the petitioners are found eligible, the same may be paid to them at an early date. Stop. Let such exercise be completed within a period of 2 months.
2 months.
2 months from the date of receipt of a copy of the order.
I will be allowed to submit this petition.
Petitioners are also permitted to submit certified true copy of
The copy of order and copy of the writ petition.
certified true copy of discourse order, along with a copy of the writ petition. to
With
the
annexes.
Respondent of writ petition with the annexes to the respondent number 4 within a period of 2 weeks. 2 weeks from today.
Item 5.
Next one, Amendment.
My lord, here the petitioner, he was placed under suspension. And subsequently, his suspension has been withdrawn. And he has been exonerated. But the salary during the period of his suspension period has not been paid.
Were you receiving subsistence allowance?
Yes. But the balance amount has not been paid. My lord. You must kindly see
Where's your suspension order?
order, page 12. No, sorry, only page is the appointment.
Place on the suspension. Annexure 1, page 10.
Excellent.
Page 12,
Yes,
correct?
yes.
Yes, that's true.
Page 10 is the type copy, my lord.
Where's your reinstatement order?
Release to the order, my lord. Page 15, my lord.
Where's it? Where's the reinstatement?
My lord.
Where's the reinstatement?
My lord, this is the order, my lord. Page 15 is the order. This is the order, my lord. I have been exonerated from the charges. Last paragraph, my lord. The undersigned further treated the period of suspension in respect of suspension was on duty for all purposes. However, this Congressional order the headmaster is hereby questions not to repeat the such activity in future.
Yes. Sharma?
Then the proposal has been sent to the authority on page 16. But not,
During the suspension period, he has not done any work, so my lord, salary has not been paid to him, my lord. So my lord issued a notice here.
Page?
my lord, page 8 is my prayer, my lord. The loss of listen. Then directing the responsible authority to release the area salary from 8/1/16 to 13 to 17. 13 to 17 is the order.
Yes, you Sham.
My lord, he was suspended on the ground of manipulation of records, my lord. So during that suspension period, he has not worked anything. So my lord,
He is entitled, my
no
lord.
work and no.
Proposal for release of error salary was sent.
Yes, my lord.
And he is entitled to salary, my lord, because he was ultimately he was exonerated from the charges. Proceeding has been dropped. Give some question. So I am entitled to get balance salary, my lord. Let the director pass appropriate order. My lord.
Madam, verify the examine the method and
Yes.
if he is eligible, then release the.
Director will pass it out.
But Mr.
Jai Hind.
J. Ahmed, learned the concept application. Also heard Mr. U. Sharma, learned standing counsel,
For respondent number 1, 2, and 3, madam.
secondary education
Secondary
department,
education department.
for the respondents 1, 2, and 3. And Mr. R. Barbujari, learned standing counsel finance. For the respondent. Stop. While the petitioner was serving as headmaster of which school? Of Kherbari High
Yes,
School
yes, my lord.
in the district of Dupri. He was placed under suspension by an order dated 8 January 2016, issued by the Director of Secondary Education, Assam. Stop. After, by order dated 2/7/2018, issued by the Director of Secondary Education, Assam. The disciplinary proceeding in respect of the petitioner was disposed of, and the period of suspension in respect of the petitioner was treated on duty for all purposes. Stop. It is the case of the petitioner that during his suspension period, he was paid his subsistence allowance, correct?
I am not clear, my lord. He say he is
Then
not.
why did you say that you were receiving your subsistence allowance? Cancel that line. By way of the present petition, petitioner is praying for error salary for the period of his suspension, i.e. from
From 8/1/2016
2016
to 13 to 2017.
Hmm?
13 to 2017.
My lord, page 11, my lord.
Page 13, my lord. His reinstatement order is 13 February 2017.
During the period of suspension, it shall not leave his headquarters. We will draw substances allowances at the rate of 50%. Draw করেছিল যে?
Oh, cancel the whole line, except that first part. While the petitioner was serving as headmaster of Fairbury High School in the district of Punitive, he was placed under suspension by an order dated 8 January 2016.
Matlab 50% he received.
Stop.
Paragraph 12 I mentioned.
1 minute. By another order dated 13 February 2017. The petitioner was reinstated in his substantive post of headmaster, Fairbury High School. Stop. By an order dated 2/7/2018. The disciplinary proceeding was finally disposed of. And the petitioner, in the period of suspension, in respect of the petitioner, was treated as on duty for all purposes. Stop. By way of the present petition, petitioner is praying for his federal salary for the period of his suspension, for his suspension period, with effect from 8/1/2016
to 13 to 2017.
to 13 to 2007. Stop. Para. The Inspector of Schools, Dupri District Circle, Dupri, by a communication dated 19/11/2019, submitted the proposal for release of arrear salary in respect of the petitioner to the Director of Secondary Education. Stop. However, till date, no steps has been taken for release of this arrear salary by the Director of Secondary Education Assam, oblique respondent number 2. Stop. Para. After considering the materials available on record, this writ petition is disposed of. Directing the respond number 4, oblique director, respond number 2, oblique Director of Secondary Education Assam, to have a verification. And thereafter, if the petitioner is found to be eligible for his arrear salary, the same shall be paid to him at arrears, but not later than 2 months from the date of receipt of a copy of the order of this court. Stop. Here also you want to submit your writ petition. Petitioner is also permitted to furnish a certified full copy of this court's order, along with a copy of the writ petition and the annexures appended to the respond number 2 within a period of 2 weeks from today. With the
Hello,
above
ladies.
writ petition in this proceeding.
Left over item 3. Wait, Your Lordship. Last, my lord, dear Lordship, I asked them to produce the record, my lord. Already they just stay order, my lord.
Who is the irrigation department?
Irrigation department, my lord. Irrigation. Order some. Not the order. In Honduras. Run a standing council irrigation department pays 2 days time to enable to receive instruction as well as produce the record. Because my lord, in transfer, my lord, the proposal has to send to the transfer committee, my lord. There is a committee nowadays, there is a SOP, my lord. Any proposal go through a committee, my lord. So where is the record, my lord? Here in this case, my lord, my brother filed a complaint, contempt case before against the chief engineer, my lord. After receiving the notice, very next day I was being transferred, my lord. That way outside the other district. That's why your lordship, my lord, arbitrariness, my lord, your lordship stayed the order. And they were asked to produce the record, my lord. And same was normally, my lord, transfer order issued, my lord, one will come and other will go. But here only I was transferred. And that's why, my lord, it is not in public interest. So the record was to police with police court.
Lordship, record I have called for, Lordship, I have not received the record. But Lordship, the thing is, Lordship, the petitioner should approach the authority first, Lordship, before coming to the court, Lordship.
Where is the record?
Record I have not received, Lordship, I need some more time to get the record, Lordship.
Let it be after vacation till then, man.
Mr. T.J. Mandal and it's in your
Record to solve for us. Into
assisted by Mr. P.K. Dekal and responsible for the petition. Mr.
N. Upadhyay, Lordship.
N. Upadhyay, Learned Standing Council, Irrigation
Lordship.
Department prays for some more time to receive instructions as well as produce reports. Stop. Please, the matter again on. When do you want?
Immediately after vacation, Lordship.
Not on 6, my lord. I need 6 minutes upon. Not on 6, 7, 8, 9 in.
10.
My lord. Till then, team order.
Team order constantly, but until the next.
Next.
10 of only.
M6.
Petitioner is presently working as assistant teacher minor in Uttar Borpokri School, Ronthali LP School presently. He was appointed in the year my lord 99, but subsequently with a group of minor teachers, he was terminated in the year 2012. The termination order is at my lord. Annexure 11, page 33, my lord. Page 33.
Yes.
In pursuance of the government under so and so, the services of 285 out of 302 teachers appointed at Dorong district as per list appeared in the inquiry report of the Deputy Commissioner Dorong and the inquiry report of the Director Administration Assam are hereby terminated with immediate effect. They were terminated. Thereafter, my lord, they were reinstated again after the order of the Honorable Court. All these teachers, whole list, they were reinstated by the Honorable Court, and in the present petitioner also, my lord, that is High Court order at page 39 and 11 paragraph is at my lord page 42. Last paragraph, page 42. It is seen that the petitioners herein are persons similarly situated in the case of the appellants in the advance of writ appeal so and so, having regard to the above, this writ petition stand disposed of the holding of the so and so, entitled to same benefits flowing out of the order at the remand passed in writable number manual. Thereafter, he was reinstated, my lord, after the order at page 45. No, page 46, my lord, annexure 14. Page 46, that in pursuance of the government approval communicated by number so and so, secretary so and so, his name appeared as my lord, name of the appointee, the petitioner. So he was reinstated on 1st of April 2022. Although my lord, order was passed same date, my lord, all these teachers were appointed on different date. Whatever, my lord, the grievances of the petitioner is that, my lord, the earlier reinstated persons, other persons, has given, my lord, that appointment order of at page 44 and 45. They have got the past benefit, but the petitioner has not been given any. Here, my page 44, as per Honorable Court order dated so and so, as per BTC so and so, Vinay Shahoria Apururi, terminated remand so and so, data remand, and when instead the same service adjusted against the sanction vacant post on so and so, so and so. The teacher concerned shall not enter in consequences, but however, he will enjoy the other consequent benefits of the law. Here in the present case, my lord, others, my lord, have been given us benefit as per High Court Order of Division Bench, but he has not been given. So he approached this court, my lord, at this time, there's only notice may be issued and my lord returnable by 3 or 4 weeks.
Then cycle. Issue.
May I please, your lordship? The order was issued by the BTC authority, lordship. Page 46, annexure 14.
It is a party name.
BTC party, lord. BTC should be a party, lordship.
Yes, my lord. I'll start copy on them, my lord, since standing counsel is there.
When they are not parties, how can you serve copy?
Yes, my lord. Mistake, my lord, typographical mistake, my lord. They were made
Whatever it
party,
is.
how it, my lord, it is missing, my lord. So, my lord, your lordship may kindly issue notice in the meantime, my lord, I'll make them party and sub copy also. my lord.
First you
I
make
think
them
so.
party. Otherwise, there's no point in issuing notice.
Is there, my lord. Okay, man, let it come after 7, 8,
Okay.
around in the meantime, my lord, I may be allowed to allowed to correct the cost title, my lord, and find an application. Allowed to correct the cost title, my lord.
You cannot correct it. You'll have to file an IA.
I file IA for impugning them.
MSN cycle and council for petition. Press for some time. To enable her to file an appropriate application for improvement of the Putuland territorial council
Kiman
as
sabah hai
necessary
kya?
parties. List after the. Where is allowed? List after the preservation.
List on, my lord, any date me fix?
You want a date fix?
Yes, my lord. Around 10th
Yes, 10th.
of October,
Item 7.
November, sorry, of like.
Well, here the petitioner, my lord, was initially appointed as a my lord, junior engineer in a Golaghat Development Authority, my lord. He is an authority, my lord, is an autonomous body constituted by the government of Assam, my lord. Subsequently, my lord, he, after an advertisement of APSC, he applied there, my lord. And subsequently, he got appointed on 8/7/2011, my lord. So his past service was not considered for his pay protection, my lord.
Yes.
Notices may be issued.
But you had danger data than the council. Issue notice. What are your sources?
Lordship.
Mr.
C. Sharma, Lordship.
C. Sharma, then standing council, what are your sources?
I am for RM Das, Lordship.
The
Appearing on behalf of
Council
RM.
appearing on behalf of Mr. R.M. Das. Standing council, water resources department appears on behalf of.
Response number 1 and 2.
1 and 2. Yeah. R. Babujari, then a standing council finance appears for response number 2. However, extra pockets information. Respondents are contractor, list of performance.
I'm obliged.
8.
May please, my lord. Matter pertaining to sanctioning regular pension to the petitioner, my lord. The petitioner initially appointed as stipendiary teacher, my lord, in 1994, my lord. Thereafter, in 2002, she is gone, my lord, for basic training, my lord, and completed. Then, my lord, from 2003, she is allowed to regular scale of pay, my lord. Then in 2019, she was, my lord, retired, my lord. Similar case was, my lord, disposed of by this honorable court, my lord. That yes, my lord. I have filed one representation also, page 76, annexure 8, my lord. Page 76, my lord.
You are claiming for all pension scheme.
Yes, my lord.
Yes.
Lordship, at the representation, there is stated that her service was regularized in the year 2004. But Lordship, here Lordship, they are not, and that record is not here, Lordship. That when they were regularized.
Page 41, my lord. Page 41, my lord. No. Not.
It is not your regular.
No, my lord, not page 41. Yes. Page 29, my lord. Annexure 4, my lord. Page 29, my lord. 17/8/2004, my lord. With effect from 25/3/2003, my lord.
Allowed to draw letters.
Yes, regular scale. And that in same line may be disposed of, my lord, after verification, my lord, as per Purnima Hor and another, my lord.
Oh, Lordship, she's allowed to get draw the regular scale of the but her
You want to take instruction?
Lordship.
Okay. What, Mr.
M. Kolita, my lord.
M. Kalita, let me concentrate. You want notice to go, or do you want to take instructions? Instructions will be
Lordship,
MS,
as convert.
S. Cornwall, Standing Council,
Elementary education, 1, 4, 6, 7, and 8.
Elementary Education Department. Press for some time to enable her to give instructions as to whether to receive instructions. There is a lot. Next after verification.
Item 9. My lord, 11 also same.
One.
Very positive matter. Dismissal of service matter. Only my point is matter excessive punishment because only his allegation that matter he allows some fact to pass without making any record matter. So anyway, dismissal notice will go my lord.
But Mr. HR is not being on a senior counsel. Assisted by AHMR Chaudhary, learning counsel for a petitioner issue notice. Who appears Home Department?
Lordship,
Unless and Bhattacharya, learned study, senior, additional.
All the respondents.
Appears on behalf of
All the
All the-
respondents.
all the respondents, accordingly, notice and respondent complete. However,
But
you shall furnish extra. copy.
by 2 more matter.
That, the respondents are voucher. 4 weeks.
Returnable matter.
4 weeks.
Obliged.
Item 10.
May it be your lordship. My lord, this matter also somehow related to item number 3, my lord. I will place the everything before your lordship. My lord, on stateway goes to page 22, my lord, annexure 4. Petitioner, he is working as a junior assistant, my lord. Page 22, my lord. I am Anup Kolita. Show cause notice, my lord. That was a show cause notice issued, my lord, on 12/10/2023. There is a show cause notice, my lord. What is the, my lord, show cause notice, my lord? I received the leave application of the, my lord, the petitioner number, that item number 3 is petitioner, my lord. The item number 3, the petitioner, my lord, who was transferred by the chief engineer, my lord, and he filed a leave application on 9th. And it was submitted, my lord. I have received that, my lord. That is why, my lord, there is a show cause notice issued, my lord. So this so-called notice, your lordship kindly see on 12/10/2023, with reference to the cited above, I have to inform you that Sri Dhurbo Lokor, head assistant of the Bishwanath Shaili division, has submitted an earned leave application on 9/10/2023. He had kept the same in leave of application on my table and said available on that file without signing signature of my official personnel. But Chief Engineer Irrigation Assam has informed that Sri Dhurbo Lokor has filed a petition where he also submitted a copy of the earned leave application received by you. It means that you have made a photocopy of the original earned leave application without informing and handed over the same to the Dhurbo Lokor, head assistant, for filing the petition. It also means that you have made a fraud by providing such document to Sri Dhurbo Lokor without informing the undersigned. You are therefore asked to show cause why disciplinary action will be taken against you. Your reply should be received this within 2 days from the so and that is issued on 12/10. And very next day, my lord, same day, my lord, I has been transferred. And I have given explanation. I will come to that, my lord. Your lordship kindly see the apex code is clearly said that in lieu of punishment is transfer is bad. Your lordship kindly see, my lord, dated 12 October. And 12 October, they so caused me and chief engineers, my lord, transferred me. In the interest of work, not public. Anup Kolita, junior assistant, office of the executive engineer, Bishwanath Shaili division. Irrigation Bishwanath Shaili hereby transferred and posted in the office of the assistant executive engineer Ratabari division, irrigation in Ramakrishna Nagar under the office of the executive engineer Ratabari division against so. The order will be came into force immediately until further order. So your lordship kindly see that, my lord, from another district, my lord, Karimganj. I am in Bishwanath Shaili. I have been transferred to Karimganj, my lord, without any, my lord, procedure followed by this, my lord, by lieu of punishment that is be done. And apex.
Where is this mentioned Karimganj?
My lord,
Where is Karimganj?
Karimganj is a separate district and it is, my lord, far away from Bishwanath Shaili. Bishwanath Shaili is near, my lord, Dorong, near Tezpur, my lord. And Karimganj in Hailagani Kasar, my lord.
It says Ratapari Patharkandi.
Ratagari Patharkandi irrigation division. Patharkandi is in Karimganj. Karimganj. So, my lord, my submission before your lordship, and very, my lord, your lordship kindly see apex code is very clear. The in lieu of punishment, my lord, that transfer order is totally bad, my lord. And that too, my lord, so cause and very same day, my lord, I have been transferred and my place nothing, my lord. No one been, my lord, and I have given reply, my lord, that is yes, I received the earned leave application. Para 19, para 20, your lordship kindly see. Para 20, my lord. The order in question will attack the principle of malice in law as it was not based on the any fact or organized for so. A transfer order based on irrelevant ground. On the allegation made against the appellant in the anonymous complaint, it has on the being on one thing to say that employee is entitled to pass an order of transfer administrative exigency, but in the authority thing to say that order of transfer passed by way of in lieu of punishment. When an order of transfer is passed in lieu of punishment, the same is liable to cessation and being wholly illegal. So, my lord, this is a punishment, my lord. They have given, my lord, even, my lord, they give me 2 days time to show cause. That reply also, my lord, I am unable to give. I have already given, my lord, but very same day, my lord, they transport me. And in my place, nobody is, my lord, transport me. Your lordship kindly see in the same day, my lord. And they, when, my lord, your lordship passed the order against that, my lord, earlier that the Dhurbo Lokor, my lord. Because that Dhurbo Lokor, your page 29, my lord, that is the order passed by your lordship. That Dhurbo Lokor earned leave application and received by me. I have putting my signature, I have received it. And same day, on 12, your lordship passed here order, my lord. Knowing that, my lord, immediately I have been, I was so close and I have been transported, my lord. So, my lord, is clear malafide and my lord. There is a procedure for, my lord, nowadays, in fact, my lord, irrigation department is the first department, my lord, they made a SOP. That any transfer order, first it has to, well, proposal has to be submitted to a committee and they will decide. But here, my lord, everything has been done, my lord. So my submission before your lordship, kindly, my lord, let them produce the record how this transfer order is taking effect, my lord. And my lord, I that may be posted along with the earlier, my lord, writ petition, my lord.
Lordship, my submission would be, Lordship. Lordship, the petitioner first go to the higher authorities, file a representation, Lordship, and then come to the court, Lordship, if his Lordship, it is not allowed, Lordship.
That is, my lord.
Lordship, in this respect, I rely upon the judgment of the court, Lordship. You join first and then ventilate your grievances, Lord.
My lord, when, my lord, they are not following the procedure, my lord, then that is a ample, my lord, right power of this honorable court to interfere with the matter, my lord. That is,
See, one thing is there, Obadia. On 12/10/2023, show cause notice was given.
and same day transfer.
To reply within 2 days. Correct.
And same day transfer order was issued.
Without, you couldn't wait for 2 days.
That is correct.
You could not wait for 2 days. Same day it was ordered.
Same date order has been passed, order has been passed. Lord.
Obviously shows the malice.
I leave it to Lordship. I think it is a fit case for suspension. It is to be suspended, not for transfer. But they pick along with the other matter, Lordship, on 10 words.
So, heard Mr. T.J. Mandal, Mr. Mayor Council, assisted by Mr. P.J. Dega.
Lordship may record my submission that he should first file representation or join in the post of transfer. That may be recorded.
The stuff. The petitioner who is serving as a junior assistant in Vishwanath Bihali division within bracket irrigation, Vishwanath Charali was served with a show cause notice on 12/10/2023 by the executive engineer Vishwanath Bihali division irrigation, Vishwanath Charali, on the ground that petitioner has committed fraud by providing what was the contention?
Contention is also not clear. Your lordship kindly see. Third para, by chief engineer irrigation Assam has informed that Chief Durbolokar has filed a petition where he also submitted a copy of the earned leave application received by you. Yes, that is correct, my lord. I have received by me. I have given. I am putting my signature in my reply. I have stated page 28, my lord. Because in there,
And he has given that copy to the petitioner, Lord.
no. That receipt copy he has taken back, my lord. The photocopy of the.
1 minute.
I have given it in mind. It means that you have made a photocopy of the original earned leave application. That was, my lord, your lordship, and his original earned leave application without informing me and handed over to the. My lord, I have received it and that photocopy I have handed over to him, my lord. I am reply, my lord. I have stated, my lord.
Was issued a show cause notice on the ground that one Shri Ruba Lakhar, head is Vishwanath Bihali division irrigation had submitted an earned leave application on 9/10/2023. And that the petitioner had made a photocopy of the original earned leave without informing the respondent number.
Last statement, executive engineers.
Respond number 3. Stop. The petitioner was therefore allowed 2 days time to make his reply as to why disciplinary action should not be taken against him. Stop. On the same day, I 12/10/2023, the chief engineer irrigation Assam transferred and posted the petitioner in the office of the assistant executive engineer, Ratapari subdivision,
In the district of Hailakandi.
irrigation. Ram Krishna Nagar under the office of the executive engineer, Ratapari Patharkanti division, irrigation Patharkanti against vacant post. Now, it is the case of the petitioner that the transfer order dated 12th October 2023 is by way of a punishment. And also not in public interest. And accordingly, the same should be deferred. Mr. N. Ubadaya,
Lordship.
London Standing Council Irrigation Department, on the other hand, submits that the petitioner should first join to his place of posting and thereafter approach this court as already held by the Honorable Supreme Court in a catina of cases. Stop. Voilà. A perusal of the show cause notice dated 12/10/2023 and the transfer order dated 12th October 2023 indicates, would prima facie at this stage indicate that the transfer of the petitioner was by way of a punishment. And in that view of the matter, by way of a punishment, stop. Accordingly, Mr. N. Obadia, Leonard, Standing Council Irrigation Department, is directed to receive instructions and also produce reports. So, voilà. Please, the matter, when is the other case listed?
10, Lord.
10,
10th of October.
10 along with WPC 608023,
Along with WBC number
6080.
6080
23.
2023. So, in the interim, the office order dated 12th October 2023, by which the petitioner has been transferred to the office of the assistant executive engineer, subdivision, irrigation, Rama Krishna Nagar, under the office of the executive engineer, Ratnabari, Patharkandi, division, irrigation, Patharkandi, shall remain till the next.
Deeply up.
Lordship, one point I have to say. The cause list shows, Lordship, it is Arup Kalita. No?
Petitioner name is Anup Kolita, but somehow by the complete in cause list it is shows a Arup Kolita. That should be my lord. Correct. Let's be very shit.
You can produce the record, then we can dispose of on the next report. 11.
Make please, my lord. It relates to my lord pension to the petitioner, my lord, regular pension, my lord. Initially, secondary teacher as my lord.
Like the same other case.
Same, my lord. Your lordship has disposed of my lord. Same similar matter, my lord.
No, that I've seen.
Yes.
With the council? Council?
Lordship, I'm coming.
Page 90 is my representation. My
What order was passed in the last occasion?
Lordship has
In
directed,
the earlier, in
Oh,
the earlier,
the instruction was taken.
Lordship has directed the Standing Council Education to seek instruction,
Instruction.
and my lord has posted the matter after vacation.
Yes,
A similar order will also be
okay,
posted,
her time, Kalita, the same order you passed.
my lord,
yes.
because on facts, my lord, they need to verify it, my lord, whether that judgment will be applicable, my lord.
Yes. That.
Lordship, here petitioner is working as assistant, junior assistant, my lord. So as per the notification, my lord, that is 25/8/2017, page 36. He is entitled for receiving the grade pay, revised grade pay, that is 6,200. Instead of old grade pay, 5,600. That was not been paid, so petitioner approached this honorable court earlier, my lord, that is page 44. Here, my lord, by this order, the honorable 44 page 55 is the relevant, my lord. Here petitioner was directed to file a fresh representation before the respondent number 2, and he shall pass and take his decision. Thereafter, my lord, he has filed page 47. Page 47, he has filed fresh representation. But my lord, nothing has been done. In the meantime, my lord, page 50, contempt has been filed. In case page 50, my lord, from third para, my lord, they said that they have paid new grade pay 6,200 with effect from November 2020. So from November 2020, petitioner is getting. But the earlier period, that is 1/4 April of 2017 to October 2020 has not been paid. Then my lord, lordship got it. Page 50.
Yes.
So from November 2020, they are paying new grade pay. So page 51, the contempt was closed by this court, my lord, by order 88/2022, lordship, page 51. And 50, paragraph 5, my lord, page 52. May I read, my lord? Page 52, paragraph 5, page 52. In view of the above, we do not find any deliberate and willful violation of order dated so and so, passed in so and so. But however, as the commissioner and of PNRD feels that there is a necessity of the clarification of the government in the PNRD department and the finance department, we require both the requirement authorities to bring in the necessary clarification at the earliest, and thereupon the commissioner PNRD to act accordingly. Paragraph 6, my lord. That the requirement of this order be communicated to the government in the PNRD as well as finance department by the commissioner, or by obtaining a copy of this order. Upon receiving said order, the two departments shall do the needful, take a decision on this aspect within a period of 3 months, but nothing has been done. So, my lord, may I pray, my friend may obtain instruction after this order, what has been.
I'll issue notice.
3 months is not even ended till now. The order was
More than 1 year.
sorry, 22, yes. Issue notice.
Issue notice.
22, right?
Mr.
P. Handick, my lord.
P. Andy Lennox, counsel appearing on behalf of Mr.
K.
K. Conway Lennox, senior standing counsel, PNRD. Affairs for respondents,
1, 2, 4, and 5.
1, 2, 4, and 5. R. Prabhujani, Lennox standing counsel, finance affairs for respondent number 2. Notice on respondents.
The extra copy.
Extra copies, if furnished. Not respondents are allowed to file contract. List after 4 weeks.
My lord, may I pray a date after 4 weeks?
It will come.
I-
This is a notice.
Party. Dear Lordship. Lordship, the petitioner was discharged from service on 28 February 2023, my lord. He is getting pension, my lord. Now I have the instruction that we do not want to pursue the case. So I may be allowed to withdraw this, my lord.
Okay, Mr.
V. Kumar, madam.
V. Kumar then goes. Submits that he has instructions to withdraw. Mr. H. Gupta then the CGC appears on behalf of the respondents, correct?
My lord.
The petition is dismissed on withdrawal.
My lord. Highly aware, Lordship.
Item 60 from supplementary list.
May please, your lordship. Look, this is against an order of recovery sought to be made from the petitioner after his retirement. The petitioner, he retired from service on 30/11/2020 while serving as registrar in the
Retirement order.
PPO provisional pension has been given to him, that your lordship will find page 20, my lord.
With your retirement order, no, we have not
yeah.
annexed.
Yes, my lord. The retirement notice, there is, that has not been annexed, but my lord, he retired on 30/11/2020, my lord. The date of retirement, your lordship will find. I'll just place.
Yes,
Yes, my lord.
page 20.
Yes, my lord. Page 20. Now, my lord, after this retirement, my lord, he was given provisional pension, that your lordship will find page 20, then provisional gratuity, page 21, and leave salary and GPF money. My lord, thereafter his case was processed for release of the final pension. Then the AG office raised an objection that your lordship will find page 29. May I read, my lord? First paragraph, in inviting reference to your letter number so and so on the subject cited above, I am to state that on scrutiny of the service book and pension paper of Sri so and so registrar, it is found that the initial pay of incumbent, i.e. from the date of joining as on 19/5/1981, has been fixed at rupees 560, which is found incorrect. As the initial pay started from the minimum pay of rupees 500 as such, the pay of the incumbent is to be fixed at 500 on 19/5/1981. Thereafter, annual increments will be granted from time to time. And accordingly, in view of, I am constrained to return here the service book and pension papers in original with a request to resubmit the case after necessary correction of the pay from the date of beginning of his service till the date of retirement, including correct fixation of pay as per ROP Rule 89/98/10/2017, as well as annual increment from time to time, and same may be recorded in the service book clearly with due attestation by the competent authority. The excess payment drawn by the incumbent from the date of beginning of service may please be incorporated in Form 19 with due drawn statement, and it should be attached along with pension papers.
Then what happened?
My lord, after this order, they have my lord, done this exercise. They have, from initial appointment 19/5/1981, they have reduced my pay and they have calculated some amount. And lastly, they have come up with this order. Lordship will find page 35. Lordship got, my lord?
Yeah.
Recovery of excess dwell, consent thereof. In pursuance of the letter under reference, you are hereby informed that recovery statement received from accounts branch an amount of rupees 10,65,081 has only to be recovered from you being drawn in excess while in service. As such, you are hereby requested to submit a consent letter regarding recovery of the amount along with modality to be adopted for the same. You know, this order is absolutely illegal in view of the OM issued by the Government of Assam Finance Department. The Lordship will find page 36. 14 June 2019, para 4, my lord. The Honorable Supreme Court, while observing that it is not possible to postulate all situations of hardship which would govern employees on issue of recovery, where payments have mistakenly made by the employer in excess of their entitlement, has summarized the following few situations wherein recoveries of the employers would be impermissible in law.
serial number 2, my lord. Recovery from retired employees or employees who are due to retire within 1 year of order of recovery, my lord. So they could not have issued this order of recovery after my retirement, that too after 3 years of my retirement. And their contention, they could not have, my lord, refixed or recalculated my pay as on 19/5/1981 after, my lord, 27 years of service, my lord, and 3 years of retirement, my lord. That is also iniquitous and impermissible in the eye of law, my lord. So I was entitled at that point of time, and my pay fixation was that point of time. How can you retrospectively do this?
Who appears?
Lordship, and it is the government, but the accountant general, they have to, because they are raising the objections on this.
Have you served copies?
Yes, my lord. AG,
It is
AG
shown
office,
also, Lord.
his name has been shown, my lord.
Okay. AG.
নাম দেখাইছে না ম্যাম?
Accountant general. আচ্ছা।
Item 60.
Anyway, we are definitely.
Yes, yes.
What Mr. HK does?
No, no, but that is it.
You want to receive instructions or you want the notice to go?
Notice, Lordship, notice will be better.
You retired as
Registrar, Directorate of Printing and Stationery.
the petitioner. Retired as registered.
Yes.
Directorate of Printing and Stationery. On 30/11/2020. After 3 years of his retirement, petitioner was served with a communication dated 15/7/2022 for recovery of excess withdrawal excess money drawn while in service. The case of the petitioner, that the action of the respondents is against the office memorandum dated 14 June 2019 issued by the Finance Department, Government of Assam, as well as the stop issue notice. Printing and stationery, you are appearing?
Yes, Lordship, 1 and 2 I may be hearing, Lord.
Standing additional senior governor. Appears for respondents,
I'm for 1 and 2, Lordship.
1 and 2. And Mr.
D. Rava.
D. Rava, learned counsel appearing on behalf of Mr.
A. Hassan Lordship.
A. Hassan, learned standing counsel, accountant general, appears for respondents,
3, 4, and 5.
3 for notice of respondents, however, extra copies.
My lord, I have an interim prayer, my lord.
Is the matter
Page 18.
forwards, the entry,
Yes, my lord. Page 18, my lord.
the communication dated. Page,
18, the prayer, my lord.
you want this state, isn't it?
Yes, stay of this order, my lord. Page 35, my lord.
Communication dated 15/7/2023. Written by Director Printing and Stationery, Assam, with regard to recovery of excess loan from the petitioner, shall remain suspended till the next.
Highly opposed.
Item 40. Ordering principal party.
My please, Lordship.
Yes.
Well, in this case, my lord, I have filed this application, my lord, for implementing my lord, the finance department as part of Disciplinary number 5, my lord. Already,
On what grounds?
my lord, earlier occasion, my lord, in the writ petition, my lord, due to bona fide mistake, my lord, finance department has not been inducted as party respondent, my lord. So, my lord, during the course of hearing,
Any objection?
No, Manat.
Barbujari,
Finance is necessary party.
but Mr.
A Hussein.
A. Hussain and the counsel for the applicants. But by this application, the applicant is praying for impeachment of
Of my lord, Finance Department,
which one?
Secretary, my lord.
Of the secretary to the government of Assam, Finance Department, Guwahati 6. As party response number
5, my lord.
5 in WBC number
WBC number 3931.
of 2020 on the ground that the finance department is a necessary party. However, due to inadvertence, the finance department was not made a party in the writ petition. So,
MD Bora,
MD Bora, Learned Standing Council,
WMD department.
WMT department, as well as R Barbujari, Learned Standing Council Finance Department has no objections. So this court has also perused the question in the present application in this. Accordingly, the player for petition is allowed. In the main writ petition in view of the order passed today in IA number so and so, let the secretary, the government of Assam, Finance Department, peaceful, Guwahati 6, correct?
Yes, my lord.
Be implemented as party response number 5 in the present writ petition. Petition is directed to file an amended cost title within 1 week.
My lord, after vacation, since from
Okay, within 2 weeks.
my lord.
Within 2 weeks from today, this up to date. Sorry.
DP of
Application.
He may serve extra copies of the petition to me, my lord.
Yes.
Petitioner may serve extra copies of the.
No, let, after that only I'll issue notice.
My lord.
Douglas.
Okay.
Meantime, you can, to save time, you can save copy. Once you file your amended cost title, automatically he'll be appearing.
Yes, my lord. Already, my lord, we have sub copy for my lord,
You can give
treasury-
extra
treasury.
copy.
Yes, my lord.
Obliged.
Item 61 for admission, order method.
Yesterday's matter, my.
Could you find any citation?
Senior government advocate, he will be appearing,
There
Lord.
are many citations in your favor.
Lordship. Lordship, senior government, Dinath, he will be appearing in this matter, Lordship.
My lord, I have serious objection. Lordship just heard both the sides, my lord. Lordship will
Kindly
kindly.
pass over for the time being, Lordship.
Okay, time being.
Yes, Lordship.
But worry, there are a lot of judgments against you. Supreme Court.
True, my lord, but what I am saying is that, my lord, the disqualification emanating from this, my lord, conviction, my lord, is now inoperative in view of your lordship's order.
No. Normally reinstatement is subject to the appeal.
No, no. My lord, after your lordship has said, state the conviction order, thereafter they have did. Had it been a case where, my lord, immediately after conviction, they would have done it, I could have understood, my lord. Now, this honorable court has stated order, my lord, conviction. It is no longer in operation, it is dormant, my lord.
Let's see.
Normally, Lordship, only sentence part is state, Lordship.
Yes.
And here, anyway, Lordship, I am not.
No, there are instances where sentences state, there are instances where conviction as well as both sentence, both are state, my lord. It is not that only sentence is state, my lord.
Item 15.
In this case, the finance department would actually file their affidavit. Sure, but that is order dated 27/11/2019.
Yes.
My lord will kindly accommodate me for 3 weeks, my lord.
Okay, at Mr. Ardale and counsel for the petitioner. Mr. R. Babujari and the Standing Council Finance Department is allowed 3 weeks time to file contract.
My lord.
Please step the 2 weeks.
So obliged.
17.
None appears to. Yes, you are correct.
Lordship.
Yes.
Matter is regarding Lordship and termination from service. I was appointed on Lordship to 2005 as a vaccinator. And since from the date of appointment, I was getting the salary for 2014.
Yes, who appears for the other side? Yeah, Gogoy.
Help.
Where's Gogoy? All this while he was happening. Yes,
My lord, Lordship will proceed after vacation. I will place on judgment relating to similar issue where my lord the termination of similar situated persons will challenge before the honorable court. The court number 17 has passed an order. I will place it by on next. It will have a bearing in the present case.
What, Mr.
P. Boiragi.
P.
Boiragi.
Learned counsel for the petition. On request made by Mr. B.
Let be after 2 weeks.
Health Department. Mr. Matter of the Puja.
I'm not.
19.
My pleasure, Lordship. Lordship, this matter relates to arrear salary, my lord. The petitioner was appointed in the year 1999. And thereafter she was against the sanctioned vacant post. Thereafter she was transferred to some other school, my lord, that is 2001. And since June 2001, she has been receiving her salary till February 2006, my lord, she has not been received. Thereafter, after 2006 till today, she has been receiving regular salary, my lord. Only from July 2001 to February 2006, she has not been received her salary. So some communications and proposal was submitted by the.
Yes, new.
My lord, I don't have the present status of the case, my lord. In fact, my lord, in 2010, my lord, way back in 2010, my lord, ISS sent a proposal to the DSC. I've asked for the instruction, my lord. I need some accord again. It's a 2017 matter, I can understand.
The whole matter, my lord.
You heard Mr.
H. Rahman.
H. Raman and the council. Mr.
S.
Nyogi, the standing council.
Secondary education.
Secondary education, praise for some time to receive instructions. List up to Puja.
After vacation, my lord.
Yes.
Obliged.
Void issue already.
Instructions exactly verify issue to have regulation like Lordship, in this matter, otherwise, Lordship, we have received our instructions. We'll have to verify, Lordship, there are a lot of petitioners who have got the job. Yesterday also some matters had come. Lordship, wherein 20.
My lord, this matter regarding non-payment of salary, my lord, since 2003, my lord. The petitioner already.
Some orders were passed yesterday.
Yes,
What
Lordship.
order was passed?
Lordship, a list has been prepared. Many people have been given.
No, what order was passed?
Order was passed, Lordship, we'll be filing an affidavit, Lordship, in this case. We'll have to verify. As to whether.
What, Mr.
A. Gohan.
A. Gohan and the council. Mr. A. Then the standing council.
Elementary education.
Elementary education department, praise for.
Lordship, 3 weeks, Lordship.
3 weeks time to
take some
file
time.
counter affidavit. Praise the Lord. List after 2 weeks.
Release, my lord.
Twenty-one.
Please, your lordship. Lordship, my lord, I would like to file a reply.
You want to file a reply?
Yes, your lordship.
You have not filed a reply.
Yes, your lordship, we have not filed it yet.
Counter has been filed.
Yes, your lordship.
Affidavit filed by respondent 1, 2, and 3.
Okay, Mr.
As Gautam, your lordship.
Yes, Gautam, let the counsel petitioner praise for how much time?
Lordship, 1 week time maybe.
1 week time to file counter, reply to the counter affidavit filed by respondents.
1, 2, and 3.
1, 2, and 3. Praise the Lord, list after puja vacation.
Oblige, your lordship.
Item 24.
Lordship, here I will have to, I need my instructions. Already a similar NPS, my lord, judgment has been given by a coordinate bench of this honorable court. Therefore, my lord, I will have to verify, as regards the facts of this case.
None
particular.
appears for the petition. Mr. A. Fukan, understanding counsel.
Lordship, A. Fukan for respondent for the elementary education.
Appears for the elementary. List after puja vacation.
Deeply.
25.
These are similar matters.
None
25
appears
and
for
26.
the petitioner, Mr. Same order.
26 as well.
Item 28.
26 to
28.
26 to
26.
Taking time.
I'm for the petitioner. He's taking time, I think, for filing a petition.
Courtesy Barwal and the counsel for the petition.
Petitioners.
Mr.
A. Fukan for the elementary.
Wait, for how much time will you require?
3 weeks.
3 weeks time to file counter.
Oblige.
Yes, after puja vacation.
28.
I'm appearing on behalf of standing counsel income tax department, Your Lordship. We had filed our affidavit and the last occasion, this honorable court has pinpointed any missing of FIR, either from the from relative or from by her wife. That has to be satisfied before this honorable court. But
Yes, who appears?
senior counsel Viswasa is there.
None appears for the petition. Mr.
Ian Gogoi,
D.N. Gogol and its standing counsel
income tax department.
appears for the income tax department. This after puja vacation.
31. Yeah, please on. Item 28.
Where were you?
I was like in other court, Your Honor. Kindly pass over the matter for the time being.
I've already passed all this after puja. Your good name?
R. Tiwari.
R. Tiwari. Heard R. Tiwari. Also heard so and so, huh? This the matter after the puja.
After vacation.
Yes.
31.
Even the last occasion also, he was no petitioner was not there.
None appeared for the petitioner on 7/2/2024. Video also meant the matter is called. None appeared. For the petitioner. We'll give you one chance.
Lots.
This after Puja vacation.
Public.
33.
None appears for the parties. Please after Puja vacation.
34.
Yeah, please.
Hmm.
This matter may come after Puja vacation. We have actually we need up-to-date instruction in this case.
None appears for the petitioner. Mr.
A Zahid.
A.
Zahid.
Jahid
Yes.
appears on behalf of the respondent number 12. Please stop the Puja vacation.
Item 35 to 46.
No, not 2 to 5.
35 to 46.
What is going on here?
Yes, sir.
Let the matter will come after vacation.
Please allow.
Actually, difficulties on my part also. This
They are supposed to get the
Matter-
instruction, Your Lordship.
matter has been dealing by
Yeah, Mr.
Upamanu.
Our Sinha, Your Lordship.
You are bringing all the matters?
Yes, Your Lordship.
Okay, hurt Mr. R. Sinha, then a conflict. Mr. Nuwadia, then a standing council.
As that's
Oh, sorry, as does then a standing council.
higher education.
Higher education, praise for
After vacation.
3 weeks time to enable him to receive instructions. You want to take instructions, correct?
Actually, they.
Your Lordship, the instruction was supposed to be produced by the Mr. D.
He was dealing with the matter. Record were called for my lord. Some of the records has been received by him. Some are yet to be received, my lord. He is some personal difficulty, my lord, some medical emergency.
No, I'm not objecting to it. What I'm trying to say is that
Okay.
as he has already been asked for the records,
Council that is on request made on behalf of Mr.
Uh,
Council,
D. Upamanu, my lord.
then a standing council.
Higher education.
higher education.
Higher education. Is the matter of the Puja vacation.
Immediately after Puja vacation, Your Lordship. May I pray for a date, Your Lordship?
You are
That
the
day?
date. Okay, 10th.
Deep
Also,
level.
47.
Lordship, fix the matter after vacation, Lordship.
You have good time?
K Kolita, Lordship.
On request made by K Kalita, learned counsel for the petitioner. This after Puja vacation.
Okay.
49.
Yes.
I'm going to eliminate it. Last occasion, my lord.
Who appears for BTC?
Last occasion, Mr. S.R. Rabba.
None appears for the petitioner. List of the Puja vacation. 50.
In this case, my lord, I need some time to for instruction, my lord. I'm for the elementary education.
None appears for the petitioner. On request made by Mr.
E Talukder,
E. Talukder.
elementary education.
Standing counsel and education is the matter of the petition.
51.
Yeah, please, your lordship. My lord, I'm extremely sorry, my lord. On the last occasion, my lord, I could not appear before your lordship because I was on leg, my lord. And soon after I came, my lord, your lordship already passed the order. Anyway, my lord, this is a case, my lord, between two wives, my lord, regarding family pension. I am the first wife, my lord, and governed by Hindu law. So second marriage is always void, my lord. Second wife name has been nominated by my deceased husband, my lord, behind my back. She was receiving family pension. This honorable court, my lord, state the operation, state the matter, my lord, and now it is stopped, my lord. Matter is otherwise ready, my lord, for this. I have annexed, my lord, next of kin, death certificate, every record I have given. I am first wife, my lord.
Yes, Talukder.
My lord. In the last occasion, honorable court asked why the second wife was given the pension, my lord. And I have received an instruction, my lord, as per my instruction, my lord, the petitioner husband, my lord, nominated her name and submitted before the authority, my lord. That's why, my lord.
Are you ready today for disposal?
What's it, immediately after vacation? My lord. Yeah.
Okay, heard, Mr.
AFNU, my lord.
AFNU Mola. Learning council for the petition on request made by Mr.
E Talukder,
E. Talukder, and standing council.
elementary education.
Elementary education is the matter of the Puja petition.
I have husband number 2.
MS
M. Bond.
M. Burman. Appears for respond number 2.
My lord, date, my lord.
Your date.
One date, my lord.
16th.
16th of, my lord, November. Deeply obliged, my lord.
52.
May it please your lordship. Lordship, this is a matter of pay parity. Petitioners were appointed as a member of various district consumer redressal forum. Lordship, my salary.
In fact, lordship had heard the matter on length the other day. It's with regard to those members of the Consumer Dispute Redressal Forum, my lord, who was seeking pay parity. In fact, on the last occasion, the government council, my lord, took time, my lord, saying that she was not prepared. That's how the matter got adjourned. Otherwise, my lord, our submission was almost was completed, my lord.
I live here.
My lord, here what had happened, my lord?
All parties are represented. Finance, Babu Jari. Civil supplies.
And I pay for all the state respondents. My friends will be there with me.
My lord, this petitioners, my lord, they are actually, my lord,
Or
working as-
should we take up after the Puja vacation?
as a lordship pleases, my lord.
Today is the second last day.
As a lordship pleases.
As a
my lord.
lordship.
As a lordship pleases.
But Mr. M. Dutta, then is also for the petition. Also heard Mr. Additional to the general. Some for the respondents. 1, 2.
All the responses.
1, 2, 4. As Mr. R. Babu Jari, we are standing on.
Very good.
Is you on date?
My lord, date may fix, my lord.
This is letter. This letter on a hearing day, you want?
Yes, my lord, we'll be hearing them, my lord.
16th.
16.
Can be 14th, my lord,
14th, I have got a few minutes.
or 21st, my lord.
21st of Feb. Let it be 16th or 16th.
Give your convenient dates.
Then let it be 28th then, 28th.
28th.
The Tuesday, my lord.
Yes, any problem?
Date is.
Your lordship is, other day also your lordship heard the matter.
Yes.
Anyway, matter is otherwise urgent, my dear lordship, this person going to retire, my lordship, that's why. I lift your lordship, my lord.
Give your dates. Give your dates.
28th of November.
28th.
28th.
Is it okay?
Well,
28.
28/11. Obliged to us.
Lordship, will kindly take up the IA number 3192. We have filed this for impleading the headmaster of the school. Lordship will recall this was the matter pertaining to release of DCRG to the employee, and during the course of the hearing, it was observed that it will be necessary to implead the headmaster of the school. That is why we have filed the impleadment application.
Where's the
IA number 3192 of 2023.
yes. Who's the party concerned? What have you mentioned?
Yes, at paragraph 2. Paragraph 2. Last line. At paragraph, page number 6. It has become, the reasons we have given, it has become necessary to implead the DDO, that is the headmaster of Kamal Singh MB School. In paragraph 3 also we have mentioned.
Party respondent number?
9.
Any objection?
We have
MS Deberger, counsel for the applicants. By this application, the applicant is praying for
respondent number 9 headmaster
of the headmaster of Kamal Singh MD School, Kokraja, as party respond number 9 in WBC number 3192 of 2023. Inasmuch as the said the is necessary party. So, MS.
He does on behalf
He
of
does.
Inayat.
Then a council appearing on behalf of Inayat, then a standing council.
BTC.
BTC has.
Respondent 225.
This court has also.
And
also 9, your lord.
He'll accept notice for 9 also.
I can't issue now. You'll have to file an amended cost title.
Yes. Yes.
Depend the petition in view of the order possible in I number so. Let so be implemented as party respond number 9. The pardon that petition is directed to file an amended cost title within 1 week, 2 weeks. 2 weeks.
2 weeks. Yes.
Which after.
Deeply obliged.
Great, Lordship. I am extremely sorry, Lordship. Item number 41, Lordship. Due to on leg in other court, Lordship, I could not appear, Lordship. Lordship, pension matter, Lordship.
Which one?
41, Lordship.
Huh?
41, Lordship. Extremely sorry, Lordship.
This is analogous matter.
49, Lordship. Sorry, Lordship. 49.
Yes.
Lordship, get me pick.
That may be fixed, Lordship. The pension matter, Lord.
List not. 20 November.
Deeply agreed.
Here also, none appears for the petitioner. List of the petition.
Wait, please, Lord. The matter pertains to pensionary benefit. Although I had retired, my lord, till date not a single penny has been paid to me. In fact, there's an order, my lord. If your lordship kindly turns to the order dated 13/3/2023, the first order, and your lordship sees in the bottom, my lord, the last paragraph, it says, taking into account of Rule 22 of so and so rules of 1969 as well as OM dated so and so, the court directs responding authorities to forthwith release the provisional pension. Now, even this interim order has not been complied with. And due to that, my lord, we had to file a contempt petition. Unfortunately, that contempt petition today has come in a different court, my lord. Court number 10 as an item number 40. So may I pray, my lord, both the matters can come up after the vacations, and my lord, some perhaps affidavit will also have to be filed.
Affidavit is for vetting, my lord.
But Mr. A.K. Barol and the counsel for the case. How much time do you require?
2 weeks, my lord.
MM Katuki, then standing counsel,
Animal husbandry and veterinary.
animal hospital and veterinary department for 2 weeks time to file. List the matter along with contempt case number.
Contempt case, my lord, contempt case number 305 of 2023, my lord.
305 of 2023.
22.
After Puja.
My lord, may I just, since it's a pension matter, my lord, may I pay for a date, my lord? Any date subject to your lordship's convenience.
22nd November.
Obliged, deeply obliged.
Obliged, sir.
Good.
Yeah, please, Lordship. Lordship, here I'm praying for some time to file our affidavit, Lordship. I'm preparing for accountant general.
Court A.K. Christian, learned counsel for the petitioner. Mr.
D. Rapa.
D. Rabba, learned counsel appearing on behalf of Mr.
A. Hassan.
A. Hassan, then standing counsel accountant general, prays for.
Lordship, after Puja vacation.
Prays for 3 weeks time to file counter affidavit. Praise the Lord.
Well, since it's related to pensionary benefit, well, let me create date. 16 November.
Yes, 16 November.
Hello.
My lord, the matter came before your lordship that day. Lordship, my lord, desired that I should file a new printed copy of the amended writ petition, which I have not. The respond number 5(4) was deleted. So respond number 5 cost title I have changed. And my lord, respond number 5 became 4. Now, my lord, this is a case you will also remember.
Yes.
This is a case, my lord, where I am a nurse, my lord, psychiatric nurse at the, my lord, Tezpur LGB hospital. There was a, my lord, disciplinary proceeding against me. The charge was that I didn't attend duty unauthorizedly for about 7 days. In my written statement, I have disputed that no, that was COVID pandemic period. There was SOP by central government. This will be on the merit. And in fact, the matron, I gave my communications that matron gave me, there were 50% attendance were necessary. So it is not a fact that allegation is not correct that it was unauthorized. Be that as it may, that disciplinary proceeding I challenged, and that disciplinary proceeding has been stayed by this honorable court in other case. And on the other, that day, my lord, earlier interim order staying the proceeding has further been extended by this court, my lord. The copy is there. Yeah. Further been. These are the 2 orders in the related, my lord. Side on this other. Yes. This should be. There are 2 orders, my lord. It will list the matter. It took a little. There was an order dated, my lord, first. 12/10/2023 order, lordship may have a look, my lord.
No, which order?
My lord, in the case where the discipline,
5622. This order is passed in this order.
my lord,
These orders are passed in this case.
yes, 12/10/23. In the disciplinary proceeding also, I produced this non-release of increment, meaning thereby that interim order passed earlier stands extended till next time. Then it has been listed again on 7/11/23. Order dated, has your lordship got order dated 12/10/23?
In which case?
In the case, my lord, in which, my lord, the disciplinary proceeding was
No,
challenged.
no, these two orders you have submitted, these are all pertaining to this case.
My lord, this is the WPC number 2209.
No, these are wrong orders.
I'll check up, my lord. I'll check up. Yes, these are the two orders. These are the two orders. Sorry. These are. These are the two orders. Lordship, first say, have a look at order dated 21/9. Since the very initiation of departmental proceeding have been challenged in the present writ petition on the ground that the attendance sheet in so and so found to be interpolated, it is submitted that if departmental proceedings are allowed to continue, writ petition will be rendered. The same, however, is objected. Considering the submissions advanced, this court is of the view that for ends of justice till next date fixed, departmental proceedings shall remain stayed. Then, my lord, it was extended by the next date, my lord. Next order to continue, not this one. I did it. No. No. Then that order was extended.
Can we not hear that along with this?
Yes, no, not necessary, my lord. That order was extended. Now, my lord, the case here is that they have already, the proceeding is going on. Allegation is that 7 days unauthorized leave, as if they have already arrived at the findings that there was an unauthorized leave, and because of the pendency, they refused to release my increments from the year 21 July till 2 years. Lordship may kindly have a look at, my lord, order dated page 99 of this petition, page 19. Why they have not released the order, page 99. Because by the previous page, my lord, I pointed out that you have not released page 98, my lord. Page 98, I made an application, not granting annual increment and CEA, my lord, children's education allowance. 21 July 22, now it is 23, my lord. Then their reply is at page 99, my lord. And that day your lordship found fault with this order, 7 December. In reference to your letter, I am directed to inform you that annual increment is not granted as disciplinary proceedings are in process and currently the matter is before the. So that means they have, my lord, they have imposed penalty of, my lord, withholding increment even before conclusion of a disciplinary proceeding. That was the subject matter, and that too. So now, my lord, they have, I am entitled, my lord, the one proceeding itself is stayed. Even otherwise, unless you arrive at a finding in the proceeding imposing penalty, how can you impose a penalty by saying that, oh, your proceeding is pending? In High Court, the matter is pending. So we are therefore not paying into NPL. That was precisely the case. And I prayed that the Lordship may give a direction 3-4 times this has come. Let them release that. They can always recover. Suppose I am found guilty. They can impose any punishment, right? From my lord, level 1 to my lord, dismissal from service. But before that, can they do it? Impose penalty. This is precisely my case.
My lord, with regard to the in connection of WPC number 2209, 2021. My senior advocate, Amit Kasa. That has been stayed, my lord, by. But for this for that petition, the petitioner challenged the appointment of presenting official of the DP, my lord, concerned DP. But sole payer is there.
No, also
Appointment-
proceeding entirely.
appointment of the presenting officer. Presenting officer already retired, my lord. Already retired, my lord. And we want to initiate DP by appointing another PO, my lord. But this honorable court state matter. My lord, petitioner admittedly he is working as an arch in the institute, my lord, in the hospital. As per notification dated at page 27, my lord, of the writ petition. This notification has been issued by the ministry for restriction for control of COVID-19 pandemic, spread of COVID-19 pandemic. In clause 6, my lord, that this says that this instruction shall not apply to the officers, employees engaged in essential emergency services and those directly engaged in taking measures to control a spread of COVID-19. And this is notch, my lord. And another also Ministry of Health at page, my lord, 124 of my affidavit. 124. My lord. It's a guideline, a Ministry of Home Affairs order number such and such.
But I'm not concerned about this guidelines.
My lord, they were exempted.
This will be considered in the DP.
DP, yes, my lord.
Right.
But
so
DP has already been stayed by this honorable court. Until the logical conclusion is come to the institute that whether his his absent was willful or not. If willful, we have to regularize that period as extraordinary leave. Extraordinary leave is if we regularize that period by extraordinary leave, he will not entitled.
You are talking about something that has not happened.
Happen, it is not counted.
See, let us be very clear.
Yes.
There's a DP pending against petitioner. Petitioner approached his court challenging the appointment of the presiding officer, correct? Court, after considering the matter, state the proceedings of the department proceeding. That is one aspect. Now, if you want to impose punishment on the petitioner.
No, my lord.
No, 1 minute. If you want to impose punishment on the petitioner, it will be on the basis of the inquiry report.
Yes.
Then the disciplinary inquiry authority on the basis of the inquiry report will pass the appropriate punishment or whatever is,
No punishment maybe.
or maybe there will be no punishment.
We are the,
So that is one different aspect. Let us be clear. Now, this writ petition. This writ petition is regarding withholding of her increment.
yes,
Correct.
my lord.
And see what the language is. Language is pending disciplinary proceeding. And as the matter is before the High Court.
No, my lord, we have clarified this, my lord, at my page 82, 182. 182 of my affidavit.
Yes.
Yes, my, the granting of annual subject matter. In continuation of our early communication from this office dated such and such 7/12/2022, it is clarified that due to the unauthorized absent from duty with effect from 26 to 2022, 5/4/2020, that disciplinary proceeding has been initiated as per rule against you, which is presently pending. Due to the pendency of the disciplinary proceeding against you, the annual increment to be implemented on 1st July 2021, 1st July 22, and 1st July 2023 is held up temporarily by the institution. After conclusion of the disciplinary proceeding, your pending dues will be released as per your entitlement and relevant. We are not the Supreme Court also says, my lord. Supreme Court, I have annexed the Supreme Court orders. My lord. It should be proof whether it is willful or not.
That is disciplinary proceedings.
Yes, my lord. My lord, if we regularize that period extraordinary leave by extraordinary granting extraordinary leave, this is not countable for the annual income or annual increment. As per pay matrix, it is how it is calculated, my lord. Pay matrix, my lord.
See,
how it is calculated, increment is calculated. Pay matrix, they have annex, my lord.
Where?
Pay matrix at a page 100, my lord. Each her basic pay is
page 100.
100. His basic pay is 480, 4,080, 4,800, my lord. And column 8. His level is basic pay is 4,800 at column 8. And the next page, my lord, is now column 8 is now drawing 72,100.
You were
72,100. On this amount, my lord, 3% annual increment is increased. 3%. And next at 74,300, it will be calculated, and 76,500, then it will be calculated. But now, because of this, whether it is absent period can be regularized by otherwise leave, special leave or otherwise, then we have to pay the increment. And if it is proved that the increment or the absent is willful, then he will be punished as per the relevant rules, but because whether he will get increment or not. That this is the problem on which we are now required to
What, what problem do you have?
My lord, it is a problem, my lord, because best,
What problem do you have? Tell me.
because if we release all the increment, then the question of initiating any DP will not arise, because it will not be valid in law.
How?
My lord, this is because whether he or she is entitled for the benefit or not, it will depend upon the DP, my lord. Because we have to calculate on this.
Are there no other punishments
And
prescribed under your rules?
and the rules also says, my lord,
Under which rules are you?
effort
Under which
26B,
provisions
my
are you proceeding against the petitioner?
FR 26, my lord.
So-
FR 26, I have annexed. FR 26, my lord, I have annexed. $171. If we pay these rules, we have to ignore the FR 26, B11,
Where's
and
FR 26?
yes, B11.
Page,
My lord, 171, my lord. One 71 FR 26 mile at the top, and this is B2 Roman 2, mile 2. All leave except extraordinary leave taken otherwise than on medical certificate and period of deputation out of India shall count for increment in the time of scale applicable to a post in which a government servant was officiating at the time he proceeded on leave or deputation out of India, and would have count to officiate but for his proceeding on leave or deputation outside, except my lord extraordinary leave. If we found that his her absent period is willful, then we have to regularize that period by granting extraordinary leave, which is not countable for the annual increment. Later,
That is not the issue. Issue is whether you can withhold the petitioner's increment due to pendency of disciplinary proceeding. And the matter being in the High Court.
162, my lord. This is the Honorable Supreme Court judgment. 162. 162.
Yes.
Farmer case, my lord. 19, my para 19.
Para?
Para 19.
1 minute.
Proof.
1 minute.
What is proof? Unauthorized absent from duty is made. The disciplinary authority is required to prove that the absent is willful.
Para?
Para 19, my lord. Required to prove
1 minute.
Let a file reply to this. My
Reply is not required, I think, Mr. Barbara.
Okay.
Reply is not required to the counter. Have you filed your reply?
Not
No,
necessary.
he's saying he's.
Not necessary. Here it says, the paragraph 19, it says, disciplinary authority is required to prove that the absence is willful.
Yes.
Have they proved it in the inquiry? They have presupposes. They have presupposed that.
My lord, he
Findings
is
is that-
claiming that he got leave, special leave from the authority.
Mr. Datta, I'll tell you one thing. Let us make things short. You concentrate on this page 99 and prepare your case. Page 99, you see whether this is sustainable in law. There's a DP is not even started, I think, because the appointment of the department, the presenting officer is under challenge. So if you want to proceed with the DP, nobody is stopping you to approach the court, praying for vacation of the interim order and proceed with the DP. After DP is concluded, if the petitioner is found that the charges are proved against petitioner, appropriate orders will be passed by the disciplinary authority. Correct? In that manner, the petitioner may be dismissed from service, may be demoted, whatever order on the gravity of the matter. Here, DP is pending. DP has not started yet. Correct? Now, you are withholding the increment of the petitioner, saying DP is pending. That is a punishment.
The punishment.
When the DP is pending, can you withhold the increment? Look at the language of the order.
It's 3%, my lord, only 3%, my lord. Only 3% is in 1 lakh 3,000.
Whether it is 3% or 1% or 5%, this court is not bothered about the percentage.
Yes, my lord.
This court is to consider whether you pass the right order or no, whether you are to be taking the correct steps or not. This is what this court has to monitor.
My lord, I have explained everything in paragraph 15 of this affidavit.
Let us see
15,
that.
my lord.
I'll give you sufficient time.
15, my lord.
Para 15 of your affidavit.
Yes, my lord. Page 113.
113,
man.
yes.
15. That as regard the statement made in para 23 and 24 of the writ petition, the deponent begs to state that as no final order of imposing penalty or exonerating from the
This is
charge
worse.
has-
You're making your case worse. Read it, read it.
No final order of imposing penalty or exonerating from the charges level against her has been passed by the competent authority till date. The annual increment of the petitioner has been temporarily held up for the reason as stated underneath. That the petitioner is absent from such and such date without leave. She has instructed by her supervisor multiple times to revert and resume to her duty. She made various excuses that she was not given any pass from for transport. However, the statement of the petitioner is not true, as because although the movement of the essential health worker are exempted during this time of COVID from any kind of restriction, authority has arranged passes for the transport of them in consultation with the district administration as stated of foregoing paragraph. My lord, it is a D, my lord. D. Willful absent from the duty is considered as service misconduct. And disciplinary proceeding against this employee has to be initiated promptly as per Government of India
So your
instruction.
affidavit is something like DB, the inquiry officer has given his report. Correct? That's it.
It has been already given, my lord, but because explanation.
Your explanation is entering into the merits of the DP, which has not even started.
Charge frame against her.
Charge is framed against her. You are entering into the charges. Has the disciplinary proceeding started? Tell me that one thing.
No, initially it started, but it was
State.
my lord.
Then
Earlier, my lord, the IO we have to change because in response to her application, my lord. And thereafter presenting official we remain the same. And therefore they challenge this. Presenting official only represent the employer. Man. We have changed the IO on their application, my lord.
Mr. Barbara, let us give him time to study this matter.
My lord.
Let us give him time.
My lord,
But then on next date, I'm not adjourning this matter.
My lord,
I've given, I think, 2 or 3 chances.
I think it is already enough, my lord. I leave it to your lordship, but this is not the.
But this is not the way you should be conducting this case. Why did you take some advice?
my lord, that other petition may be tagged with this, my lord.
No, that is a different matter.
Right from day
So
one,
we are
right,
now,
my lord, right from day one,
Even
he,
if that matter is tagged with this order has to go. The finding in that writ petition where the DP is challenged may be something different. May go against the petitioner, let us assume. Still then this order will not survive. Because DP is yet to conclude.
because of the
my lord,
all
I
these,
think valuable time of the court, my lord, my time, no problem with that. Last 3 dates, my lord, same submission, your lordship had heard, my lord. If still your lordship thinks, then I leave it to, but the court's hours are very valuable.
maybe,
And
because
lordship
my
said,
lord,
my lord, your lordship's first order, first day's order, 410. An attempt shall be made to dispose of the petition on the next day. Your lordship said.
Correct.
Thereafter, your lordship heard him 2 days, today is the 3rd day, same submissions. He has not been able to improve, my lord, with due respect. Lordship has seen it, and court's hours are valuable. About me, no problem. I can appear on 10, as many as 10 days. But your lordship's time is precious. So it is high time that this matter is disposed of, my lord. With a direction. But small thing.
my lord, let me just say that I'm paying for a direction to the petitioners to file an affidavit because
Filing an affidavit is not the prerogative of this court, nor it is the prerogative of the petitioner, whether he files to file a reply or not. Counsel has said, I'm not filing reply. What more do you want?
we were obstructed because of the rules, my lord. Rules, my lord.
What rule?
That app.
None of FR 26, nothing obstructs you. If you want to study the matter again, I can again give you one last chance. But then, no. If you come with the same submission, that day I'm going to stop you in 1 minute.
Well, and then it takes along with that petition.
Not required.
I'm not saying that he is not entitled or entitled. It's depend upon the. I know on what basis we will fix his increment.
You'll know better. That you know better.
This is the parametric that is there, my lord. The direction is there, how to calculate.
You want to go for disposal today or you want time? Tell me.
Then another thing, my lord.
That day I'm telling you, I'm busting in order now and I'm keeping it parted. But AC Barbara, senior counsel, assisted by MS.
NMD.
NMD, senior counsel for petition. Mr. On request made by Mr. A.K. Datta and the counsel for the respondent, please the matter again on
After 7 months.
9th November. So, as sufficient time has been given to Mr. A.K. Datta, it is made clear there shall be no adjournment on the next date fixed. So, this, I said 9th, no, as parted.
Right.
Hopefully, the next date will be last date, my lord.
Yes.
Lordship may indicate that also. Lordship may indicate that.
No, I've always said that sufficient time has been given.
Oblige, lordship.
I'm sorry to interfere at this stage. When the item 50 was called for lordship, I could not present lordship. I was in court number 8 lordship. This is lordship, I think lordship, my name is petitioner for absent lordship. My name may be recorded lordship. Otherwise,
Okay.
government is directed to obtain instruction lordship. Item 50 lordship.
50.
Probably petitioner for advocate for is absent lordship. So my name may be recorded. lordship.
Okay, her date, decor, and the constitution. What did I pass? On request made. Okay.
Deployable lordship.
Item 57 for orders. Why is it coming for this today? None appears for the petition. List of proposal. 59. 59 is abroad.
May I please, your lordship, my lord? Yes, my lord.
Yes.
The petitioner before your lordship, my lord, he is holding the post of headmaster, my lord, in a MA school, my lord.
Why is it coming for orders today?
My lord,
Respondent number
on the-
6 has not served, my lord. It's not.
I have taken registered step in the respondent number 6, my lord. He has not entered into appearance, my lord. My lord, my interim is still under consideration, my lord. Lordship will kindly allow me 2 minutes time to make submissions before your lordship, my lord.
Issue is this.
Issue is this, my lord. On the basis of a, my lord, show cause notice, my lord. My lord will kindly have a look at page 20, my lord. Annexure 4. A show cause notice was issued from the office of the block elementary education officer with some allegations, my lord. Page 20, my lord.
Oh.
Lordship will kindly have a look how the allegations and the manner in which the allegations have been leveled, my lord. May I read them, my lord? There are, my lord, 5 points, my lord. My lord, yes. Point number 1, you are found most irregular in your school duty and also you were found unauthorized absent from 1st August 2023 to 5/8/2023. Moreover, you put your signature from 1st August 23 to 5th August 23 in the teacher's attendance register during your absentee period. Point number 2, my lord, will kindly have a look, my lord. It is informed me Now, who has informed, my lord? That has not been mentioned, my lord. And as per on the basis of information, my lord, he has issued this notice, my lord. It is informed me that you served MDM irregularly among students and also poor quality MDM which were served in your school. Again, my lord, in point number 3 also, it is informed that you have misused of the entire electricity fund which was released from district authority in the last financial year. Number 4, it is also informed that you have not distributed any uniform among the students for the last financial year. Number 5 is it is found that you left the school immediately after the break time on 16th August 2023 and 17th August 23 and duly signed in the teacher attendance register. These are the 5, my lord, allegations, my lord. And I replied to this, my lord, show cause notice. In the next page, lord, you will find page 21, my lord. My lord, will kindly have a look, my lord.
Yes.
This is my reply, my lord. Page 21. The allegation of absent from 1st August 2023 to 5th August 23 is correct. I take full responsibility. I signed unauthorizedly from 1st August to 5th August 23. And I promise that this kind of unlawful activity will never happen again. He has admitted, my lord. He did it, my lord. And in regarding second point, the allegation of irregular and poor quality MDM is absolutely wrong. MDM is regularly served with top quality. Number 3 is the allegation of misuse of the entire electricity fund. I have to inform you that the fund of electricity has not been withdrawn due to KYC problem. He could not withdraw the fund, my lord. Because of KYC problem, the headmaster could not withdraw a single penny even. Number 4, the allegation of uniform. I have to inform you that the vendor did not supply on time in spite of several contacts. But the vendor decided to provide the uniforms on 19/8/2023. And regarding number 5th allegation, my lord, page 22, my lord, the allegation that I left the school after the break on 16th and 17th August 23. I was present for the whole day on 16th August 23 and 17th August 23. I have to state that on 16th August 23, I was present for the day, and allegation for 17th August 23, I left the school at 11 a.m. due to my physical weakness. But while I took some rest at home, my physical condition got better and I come back immediately to school, my lord. My lord, regarding all the allegations, my lord, only point number 1, my lord, he remained absent for 5 days only, my lord, and that he admitted, my lord. And without conducting any, my lord, field verification or providing any further opportunity, my lord, on the basis of this show cause notice only, my lord will kindly have a look on page 25, my lord, Annexure 6, my lord. I was transferred, my lord. And in my place, my lord, I have been demoted even, my lord. I was holding the post of headmaster in a ME school, my lord, and I have been, lord, may I read, my lord, as per proposal of the Block Elementary Education Officer, Lahore, Ghat, by his letter number so-and-so, dated so-and-so. For the greater interest of public service and smooth functioning of the school, Muhammad Akhtarul Haq, he is the respondent number 6, my lord. He joined in the school in the last year only, my lord. Assistant teacher of Alipukhuri ME School, LP section. Under the Lahore Ghat Education Block is hereby allowed to responsibility of the charge of head teacher in the said school instead of Muhammad Amdad Hussain Chaudhary, and he is the petitioner, my lord. And Amdad Hussain Chaudhary, head teacher of Alipukhuri ME School under this Lahore Ghat Education Block is hereby allowed to work at Kahipari LP School under the same education block purely temporary due to single teacher school. Now, my lord, I beg pardon of your lordship's permission, my lord, to produce one, my lord, order that I have obtained, my lord, after filing of this writ petition, my lord, which states that the school where I have been transferred, my lord, that school is already having 3 teachers, my lord, including the, my lord, the earlier headmaster, my lord. I may be allowed to produce that order.
You will have to incorporate by way of an additional affidavit.
That I understand, my lord, but by yesterday, my lord, only I have received this particular order, my lord. Or she will, I have marked it, my lord. Serial number 7, my lord. In the order itself, it said that because of single teacher, I have been transferred to the school, the other LP school, demoting my post, my lord, without proving the allegations, my lord, without conducting any inquiry, my lord, without having the field verification, spot verification. Now, she will kindly have a look at that particular order, my lord, serial number 7, my lord. Serial number 7, my lord. The school of, my lord, another school, my lord, that is number 2, Noburchor LP School. That school has been merged with Kahipuri LP School, and the number of teachers are 2, my lord. Meaning thereby, my lord, including me, now 4 teachers are there. And I have been informed, my lord, that altogether only 45 students are there in the school, my lord, where I have been transferred, my lord. Is it the requirement of a school, my lord? Having only 45 number of students, my lord, I have been, my lord, punishably transferred without holding any verification, my lord, without providing me any further chance to hear, my lord. My lord, the manner in which this order has been passed, my lord. The DEO, he should have, my lord, conducted one field verification, or I should have been
Have
called.
you joined the post?
No, my lord.
Why?
My lord, even, my lord, after passing of this order, my lord, no separate order has been passed, my lord, with a direction to hand over the charge to the present, my lord, the respondent number 6.
Isn't this order sufficient?
My lord, the manner in which this order, lordship will kindly consider, my lord. Is it the requirement, my lord? This school is having
This
already
order
3
was
teachers, my lord.
Passed on 5th of August.
I immediately challenged, my lord.
September.
I immediately challenged, my lord.
When
On,
did you challenge?
yes, my lord. And
Was there a stay order granted?
my lord, that was under consideration. On the very first day, my lord, it was specifically, my lord, mentioned. Observation was made on 13/9/2023, my lord.
Then
That is still under consideration. That's why, my lord, I'm before your lordship, my lord. Just to consider my interim prayer, my lord, at this stage, my lord. It is still under consideration.
it says will be considered only after receipt of relevant instructions. Correct?
Yes. Now I'll leave it to your lordship, my lord. Since I have produced one another order, my lord. May I pray before your lordship, my lord?
What order?
My lord, this order, my lord, the separate order that I have produced, my lord. Which shows that the school doesn't have one teacher, my lord. The school consisting of 3 teachers, my lord,
Yes,
except
you have instructions.
judgment.
Right now, no.
Then how can we consider? Order is very clear.
That I have seen.
The interim
My lord,
My lord,
prayer.
the order says that the school is having only single teacher. But
Mr.
that, my lord.
Ahmad, you read the order of this court.
Yes, my lord.
Last paragraph, the
Yes.
last line. What does it say?
That order is not with me, my lord. I have seen it already.
The interim prayer of the petitioner shall be considered only after receipt of relevant instructions. And who are supposed to take instructions? Mr. N.G. Katania, Learner Standing Council Department.
My lord, he has not appeared today, my lord.
Does it?
My lord, this is my humble prayer, my lord. Till they get the instruction, my lord. Till then, my lord, at least I should be, my lord. My interim
Kindly
prayer may
peruse
kindly
the-
be, my lord, considered, my lord.
My
Or she
lord,
will kindly consider, since I have not joined the school, my lord.
Why have you not joined?
My lord, no separate order has been passed, my lord. And even, my lord,
What separate order is required?
my lord,
Isn't
no
this
direct,
order
specific
sufficient?
direction, my lord, to hand over the charge. Normally, my lord, what happens, my lord? After passing of this such kind of order, my lord, a separate direction is issued to the person concerned to hand over the charge to the, my lord, person who has been
On
given the
one
charge.
side, you are not attending your school.
My lord, I am attending the school, my lord. Although, my lord,
You did not attend and then you went and signed after you joined the school.
my lord, only for 5 days that I admitted, my lord.
Isn't
Except
that
that, my lord.
5 days for teachers?
Lord,
Is it not
Except that,
very
my lord,
important?
all the allegations, my lord.
What happens to the students who are not taught
My
for
lord,
5
only
days?
for 5 days. I have my physical problem, my lord. My physical condition was not good, my lord. I am having hypertension and diabetic, my lord. Severe diabetic. my lord.
Everybody has that.
I understand, my lord. I have admitted.
Even I have.
My lord, having the, my lord, if your lordship kindly considers upon the allegations that has been leveled, my lord. My lord, except the first allegation, I
Yes.
remain absent for 5 days only, my lord.
My lord, kindly peruse the impugn order, my lord, 25, last paragraph. It is to be stated that this temporary arrangement
Yes.
and it may be cancelled without any reason thereof.
Every order is passed, my lord, in such manner, my lord.
This arrangement is made keeping in view of among functioning of the academic work and midday meal. And this specific allegation against the respondent number 6, my lord. Kindly see the page 4.
No, have you received instructions?
No, my
This is
lord.
what I'm asking you.
No, my lord.
Why? More than 4 weeks has gone.
My lord.
More than 47.
So lordship, my pray for tomorrow or my lord.
Not tomorrow.
Immediately after.
Tomorrow is the last day, my lord.
On-
Therefore, my lord, I am praying, my lord, till they get the instruction, my lord.
I can't possibly-
Lordship will kindly, my lord, consider my interim prayer, my lord.
I'm sorry.
Till they
not-
get the
not-
instruction.
6, my lord, 6 November, I will.
I'll also
stand.
document it.
Lord,
Then I'm-
today is the, my lord, same.
On request made by Mr.
B Talukdar,
B. Dalukta, Understanding Council,
elementary division,
is the matter on 6.
6, my lord.
We are able to receive.
My lord, sufficient time was given to
Right.
them, my lord. They're not having the instruction, my lord. I am suffering, my lord. My lord.
You are supposed to go and join your school when there was no interim order passed.
My lord. Lord. But my interim, my lord, may kindly be considered on the next date, my lord. That observation may kindly be made.
Shall be considered on the next return.
I'm waiting for
Mm.
FY number 3, Lord.
MSDD Barman, Government Advocate, address for one number 3.
I'm highly obliged.
May I please your lordship?
Hmm.
Lordship, item number 57, lordship. I could not reach lordship. Item 57, lordship, the
Yes.
petitioner, already their disputes has been settled by the department, lordship.
Hmm.
So petitioner is not willing to pursue this matter, want to withdraw, lordship.
Item
amicably
57.
57 lordship.
Mr.
Nojid Ali,
Mr.
SK Sarkar.
SK Circle level counsel for the petitioner submits that he has instructions to withdraw this.
Withdraw this petition lordship.
Who appears for the other side?
I am for the limited.
Mr.
B Talukar.
P. Talukar and the standing counsel appears for the elementary.
I will appear for the finance department.
Mr. P. Chalial and the standing counsel appears for finance department. So, the petition is dismissed on withdraw.
Lordship, highly obliged lordship.
One more matter is there.
Discipline force lordship, so he has to be, that means as he is involved in a criminal activity and this has been proved beyond doubt lordship and he has been convicted and sentence has been passed. So he should not, he has been rightly dismissed.
Not.
And lordship, second thing is lordship, even if there is a stay of the order, it cannot take away his involvement. The conviction or sentence, whatever has been.
No, that's a different thing. That's
Yes,
a different-
lordship. This.
But there are a lot of judgments in your favor. Why don't you get one or two?
Lordship, there are, but exactly as lordship is just.
On that point itself, there are so many. judgments.
Yes, lordship, but whatever I have got little different lordship. The Sushil Kumar case, then the.
Most of the judgments are against you.
Samnaran Day.
When your lordship says that, yes, automatically it doesn't, my lord. But here is a case, my lord, on facts and circumstances, it's a little bit different. Conviction, no dispute. I am convicted, my lord. This honorable court stayed the entire conviction and sentence. Had it been the only sentence, I could have understood. It has been stayed. Now, my lord, it's not that that conviction good, but it becomes dormant. It becomes inoperative. Any vice emanating from such conviction will remain as dormant, my lord, as inoperative. I am not saying that lordship will quash it. That's not, my lord. But it will become dormant. And thereafter, after stay, my lord, they dismiss me, my lord. It's that too summarily by invoking exception to that Article 311(2). That could not have been done, my lord. So what is my humble prayer? That you take me in service and it will be subject to outcome of the criminal appeal, my lord. That is my humble prayer.
There are many judgments which says your reinstatement shall be subject to the outcome of the appeal.
Yes, yes, that is what I am praying.
No, your reinstatement shall be subject to the outcome of the appeal.
Lordship, yesterday
the other way around.
submitted this.
No.
Lord.
My lord, when a disciplinary proceeding is conducted and I am, my lord, in a criminal, there is simultaneously a criminal case and on the same set of charges I am discharged or dismissed, then, my lord, this principle will apply. Here, my lord, my humble submission before this honorable court is that, yes, there is a disqualification once a government servant is convicted. I am not disputing that. But whether the disqualification remains to be operative when an honorable court stays that conviction, it doesn't matter.
Why didn't you get some
And-
judgments? Come back.
Lordship, I can get, but.
We'll take it up
this-
on 6th.
Lordship, this will be more,
Yeah,
I'll be.
give you more time. But
Lordship.
on
Your
that
lordship,
day- on
kindly
that
allow
day,
me.
we'll discuss
Yes,
about
lordship.
that. And you also find some few judgments.
Navjot Singh Sidhu, I have anyway, I'll satisfy you.
Heard J. Bhattori, then a petitioner, also heard M. Bhattacharya, additional senior government advocate. Heard in part, it is on 6th. You on 6th or him on the opening day? Is it okay? Are you available?
Okay, Lordship, 6th is opening day.
Yeah.
Yes, Lord.
Is it
Can
okay?
be. Lordship.
Yes. The day you bring judgments, we'll see.
True. You'll assist a lot.
Lord.
I've got some, but I don't
Yes,
want
no,
to. I don't
lordship,
want-
the proposition you have fallen from your lordship is, I'm not, it's true, but that is when a disciplinary proceeding is conducted, and at the same time, similar set of charges, criminal case is also pending, and I am, in the meantime, in a disciplinary proceeding, I am dismissed or dismissed.
It's a case of this thing. See, in a criminal proceeding, conviction is made.
No.
We went an appeal, High Court state the appeal, state the conviction and sentence, whatever it is, judgment.
My lord.
The Supreme
Judgment
Court-
includes both.
Yeah, Supreme Court says no. Still then, you cannot be reinstated.
And there is no reason as such, Lordship, the where the staying and all these things. So I'm not going into these details, Lordship. But
See,
I will assist a lot.
I would not like to allow or dismiss a writ petition just like that.
Lord,
Yeah, I want to give you sufficient time.
Lord,
Both of you have some.
We'll
in-depth
assist
study.
you, Lordship.
will oblige Lord.
So far as my thing is concerned, even after that, reinstatement is not possible.
My lord, my lord. Yes, that is a plausible view. I'm not disputing, but there are exceptions, man. Anyway. we-
Finish. Oh, this is the last item. Okay.
and Deeply aware.
Oblige your Lord.
Weight to be given to the spaces of evidence on account of the existence of many circumstances which may affect their truth. The situation in which a man is on the deathbed is so solemn and serene is a reason in law to accept the veracity of his statement. It is for this reason for the requirements of oath and cross-examinations are dispensed with. Since the accused has no power of cross-examination, the courts insist that a dying declaration should be of such a nature as to inspire full confidence of the court in its truthfulness and correctness. The court, however, has always to be on guard to see that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court also must further decide that the deceased was in a fit state of mind and had the opportunity to observe the identify the assailant. Normally, therefore, the court, in order to satisfy whether the deceased was in a fit mental condition to make the dying declaration, looks up to the medical opinion. But where the eyewitnesses state that the deceased was in a fit state and conscious state to make the declaration, the medical opinion will not prevail, nor can it be said that since there is no certification of the doctor as to the fitness of the mind of the declarant, the dying declaration is not acceptable. A dying declaration can be oral or in writing, and any adequate method of communication, whether by words or by signs or otherwise, will suffice, provided the indication is positive and definite. In most cases, however, such statements are made orally before death and is reduced to writing by someone like a magistrate or a doctor or a police officer. When it is recorded, no oath is necessary, nor is the presence of a magistrate absolutely necessary. Although to assure authenticity, it is usual to call a magistrate, if available, for recording the statement of a man about to die. There is no requirement of law that a dying declaration must necessarily be made to a magistrate, and when such statement is recorded by a magistrate, there is no specified statutory form for such recording. Consequently, what evidential value or weight has to be attached to such statement necessarily depends on the facts and circumstances of each particular case. What is essentially required is that the person who records a dying declaration must be satisfied that the deceased was in a fit state of mind, where it is proved by the testimony of the magistrate that the declarant was fit to make the statement. Even without examination by a doctor, the declarant can be acted upon, provided the court ultimately holds the same to be voluntary and truthful. A certification by a doctor is essentially a rule of caution, and therefore the voluntary and truthful nature of the declarant can be established otherwise. Then 18.3, the Constitution Bench affirmed a view in Kohli Chunilal Sabzi while holding that Paparamba Rasamma was not correctly decided. The court said it is indeed a hyper-technical view that the certification of the doctor has to the effect that the patient is conscious, and there was no certification that the patient was in a fit state of mind, especially when the magistrate categorically stated in his evidence indicating the questions he had put to the patient and formed the answers elicited was satisfied that the patient was in a fit state of mind, whereafter he recorded the dying declaration. Therefore, the judgment of this court in Paparamba Rozamba state of AP must be held to be not correctly decided. We affirm the law laid down by this court in Kohli Chunilal Sabji state of Gujarat. In Dal Singh case, the court has pointed out that the law does not provide as to who could record dying declaration, nor is there a prescribed format or procedure for the same. All that is required is that the person recording dying declaration must be satisfied that the maker is in a fit state of mind and is capable of making such a statement. This court also pointed out that as to whether in a given burn case, the skin of thumb had been completely burned or if some part of it will remain intact, would also be a question of fact. This court said the law on this issue can be summarized to the effect that law does not provide who can record a dying declaration, nor is there any prescribed format or procedure for the same. The person who records a dying declaration must be satisfied that
the maker is in a fit state of mind and is capable of making such a statement. Moreover, the requirement of the certificate provided by a doctor in respect of such state of disease is not essentially in every case. Undoubtedly, the subject of the evidentiary value and acceptability of a dying declaration must be approached with caution for the reason that the maker of such statement cannot be subjected to cross-examination. However, the court may not look for corroboration of a dying declaration unless the declaration suffers from an infirmity. So far as the question of thumb impression is concerned, the same depends upon facts as regards whether the skin of the thumb that was placed upon the dying declaration was also burned. Even in case of such burns in the body, the skin of a small part of the body, that is a thumb, may remain intact. Therefore, it is a question of fact regarding whether the skin of the thumb had in fact been completely burned, and if not, whether the ridges and curves had remained intact. In Bhagavan, this court accepted the dying declaration made by a person having suffered 92% burn injury and whose continued consciousness was certified by the doctor. This court referred to the decision of Vijaypal versus State of NCT of Delhi, where the statement made by the victim having suffered 100% burn injury was also accepted. This court said, Bhagavan case so and so, can a person who has suffered 92% burn injuries be in a condition to give a dying declaration? This question also no longer res integra. In Vijaypal versus State of, she could not have made any statement to her brother. In this regard, we may profitably refer to decisions of Mafabhai Nagarbhai Raval versus State of Gujarat, wherein it has been held the person suffering from 99% burn injuries could be deemed capable enough for the purpose of making a dying declaration. The court in the said case opined that unless there existed some inherent and apparent defect, the trial court should not have substituted his opinion for that of a doctor. In the light of the facts of the case, the dying declaration was found to be worthy of reliance. Instead of MP versus Dal Singh, two judgments placed reliance on the dying declaration of the deceased, who has suffered 100% burn injuries on the ground that the dying declaration was found to be credible. Therefore, the mere fact that the patient suffered from 92% burn injuries, as in this case, would not stand in the way of patient giving a dying declaration, which otherwise inspires the confidence of the court and is free from tutoring and can be found reliable. Lordship, in our case in hand, my lord, the certificate of doctor was there, that the patient was in a fit state of mind, my lord. In fact, the requisition was also given by the IO, Lordship, that the dying declaration be recorded. It's the opinion of the doctor which matters, my lord, because he recorded the dying declaration. It's up to his mental satisfaction that the victim was in a fit state of mind to give the dying declaration, my lord. So, your lordship, in our case, my lord, the dying declaration can be the sole basis for conviction, my lordship. And one more judgment regarding, my lord, that hostility part. I'll just refer the judgment 2016. I'm sorry, I could not give the citation earlier. 2016 3 SCC 108. 2016 3 SCC 108. It's regarding hostile evidence. Krishan Chandar versus State of Delhi, my lord. I'll rely on para 2720.
Pardon?
Para 2720. Lordship, I'm sorry I could not give the citation. The book list did not give, my lord. And it's not a case of the defense that there was some previous enmity. Motive could be gathered from the evidence of this one, my lord, husband of the victim, before whom also dying declaration was made, my lord. Because of laying of egg, my lord, the lordship, that there was quarrel among the parties, as a result of which, my lord, she was burned down, my lord. And they only asked her, the deceased, the victim, to dip herself into the water, my lord. It has come up from evidence. So motive could be, lordship, although lordship, it can be a case under 304 and come under general exception, but looking into the lordship gravity of the offense, my lord, looking into the injury received by the victim, lordship, may I pray, my lord, your lordship will affirm the conviction under 302, my lord. That is my respectful submission.
Lordship, as far as the case laws that that has been referred to, three things, Lordship, I would like to place. First is that yes, I mean there is not a prescribed format or prescribed person who will have to take the who has to record the dying declaration. So that Lordship has to see on the facts and circumstances of the case. But as far as that case is concerned, the magistrate was there. And secondly, the most importantly, Lordship, what has happened in this case is that in that case, the content of the dying declaration was not under challenge. But here in this case, Lordship, as far as four PWs are concerned, they have disputed the contents, because in the dying declaration, these witnesses have stated that name has not been taken. But in the dying declaration, the name has come. The content of the dying declaration is under challenge. Under challenge means by way of the coming of the witnesses, the evidences, because there are contradictory evidences in the content of the dying declaration. And thirdly, Lordship, this dying declaration, when it was taken, then three witnesses were there. And two witnesses, in fact, specifically stated that they could not understand what has been stated by the deceased. And they have specifically stated so. And while taking this, recording this dying declaration, the doctor who has taken the dying declaration, he has not read out what has been written there. What has been written there that hasn't been read out to the witnesses. The witnesses do not know what has been written there. They have just simply put the signatures. That has come in the evidence. So those three aspects, Lordship has to look into. That is my humble submission as far as this dying declaration part is concerned.
Confronted, the witnesses has not been confronted as to the Lordship submission made by my learned friend, Lordship, that it was not read over my lord. It remained unchallenged. The credibility of the witness, my lord.
No, that has come under the cross-examination part.
I don't think so.
That has come in the cross-examination part. The content was yes.
Of the doctor.
No, not doctor. PW2, PW3, PW2 and 3 has been declared later on declared hostile. That is different thing. But as far as witnesses are concerned, that Geeta Devi, who was a nurse, and Ajit Burman, who was a constable, they specifically stated that they are not aware of the context of dying declaration. Contents of the thing. So contents was not read out to the witnesses. In fact, there is a statement made by that they could not understand what has been stated there. And one witness, Geeta Devi, has specifically stated that 2-3 persons entered the house. No name has been taken. But in spite of that, in the dying declaration, some name has been put into. So the contents have been challenged. Contents of the dying declaration have been challenged, and that is the moot question here also.
Lordship, one more factor. The person who recorded the dying declaration is the official witness. He has no enmity with any of the parties. Why would he come up before the court below and put his evidence, Your Lordship, regarding dying declaration? My lord.
Only two things. Only as far as dying declarations. First is that they are relying on the constable, my lord, and the Lordship would find the constable says that in his cross-examination, Ajit Burman, my lord, he says that the woman was in a speechless state. This much. Second part is that Geeta Devi says that she could not understand what they said. Now the third witness, Sikha Pandit, never turned up to the court, and the IO says that the husband, Piyush Pandit, was not at all present, my lord. If I can show this only. And that apart, my lord, even if the certification has been there, the doctor has not even specified what medicine he gave, and he is the PW4, and what he writes is that only one line of the doctor who took the dying declaration, he said, as the victim could not move her hand, so I held her heart to put thumb impression on the declaration. I did not sign after endorsing the thumb impression. He himself has not given his signature. The doctor who has taken the dying declaration is there in his cross-examination. So the four witnesses, they are relying. Ajit Burman said she was in a speechless stage. The Geeta Devi, the nurse. Now for the nurse, what I'll place before your lordship is that kindly see this certificate. Prior to writing the dying declaration, the name of Geeta Devi is not at all there in the dying declaration. Only three witnesses' names are there. Ajit Burman, Sikha Pandit, and Piyush Pandit at page 85. For a moment, Malik.
About the nurse Geeta Devi, there is no mention. Page 85. Page 85, my lord. There are 3 witnesses only, my lord. Ajit Burman, Sikha Pandit did not turn up. Piyush Pandit, as per IO, he was not present in the hospital, my lord. My lord has seen that, but in the signature part, now this Geeta Devi signature comes. No, Piyush Pandit. So, my lord, here, my lord would find that Geeta Devi, in fact, in the signature, her names comes, but prior to that page, your lordship will find only 3 witnesses were present, my lord. Ajit Burman, Sikha Pandit, and Piyush Pandit. Now, Sikha Pandit never turned up to the court, my lord, to depose her statement, my lord. Piyush Pandit, husband, as per the IO, my lord, she was not present in the hospital. I'll just show your lordship. Geeta, my lord, at page 35, my lord, the IO's cross-examination, page 35, my lord. Page 35. Cross part, my lord. Page 35. Last above 3, my lord. The husband of the deceased was not present at the time of treatment given in the hospital at Jugijan. So the husband was not there. The Piyush Pandit I'm referring to. So he was not at all present. How come his signature and his deposition can come in the dying declaration once he was not at all there in the Jugijan hospital, my lord? So, my lord, the 3 witnesses they are relying on, 2 did not turn up, 2 were not there in the hospital. 1 constable was there, and he says that she was in a speechless state, my lord. And the doctor says that I have not endorsed the signatures, I have not endorsed the thumb impression, my lord. So, my lord, I'm not saying my lord will see the records and my lord will pass appropriate orders. But as far as the credibility of the dying declaration, I'm showing that this is the credibility of the dying declaration which is before your lordships.
Lordship, if your lordship discussed that part, my lord, that the witnesses are not there and the material witnesses were not examined. But still, your lordship, the maker of dying declaration, the doctor, his evidence still remains unshaken, my lord.
No, my lord, 98 to 99% burned, my lord. After giving sedative, my lord,
Yes, I have
a lady cannot, my lord. A lady cannot speak out, my lord. Because once I see a victim coming to the hospital, being a doctor, initially what I'll do is that I'll relieve her by giving certain medicines so that she gets relief of the pain. She's thereafter, my lord, 98 to 99%. There is no possibility of, my lord, there being a dying declaration, my lord. And after I have shown your lordship, the witnesses, those who they themselves, it's the prosecution case. Now their witness from their witness.
Is not a doctor, your lordship.
No, I'm not a doctor.
Cannot stand in the.
But as far as the evidence part is concerned, I've shown your lordship that out of the 3 persons who were present, my lord, 2 did not turn up to the, because it is their evidence from where I have shown, because I'm an amicus only. But still I have shown that Sikha Pandit was not there, Piyush Pandit was not there. Now the constable says that she was in a speechless state, and the doctor says that the person who records, I have not endorsed. So I need to, had that been a part that yes, I have endorsed, she was in a fit state of condition, I have taken the signature, I have put that. Nothing is there, my lord. My lord, a thumb impression can be taken of a person after his death also, my lord, because the fingerprints remains, my lord. This is
Lordship, regarding non-examination of material witnesses is relying on that part. 2007, 15, I'll just give the citation. 2007, 15 SCC 393. I'll give the reference. 2007, 15 SCC 393, Umesh versus State of Maharashtra, para 19. It's not fatal to the prosecution. Obliged.
But I Talukta. Then it comes to the appeal and criminal appeal number 287 of 2019. S.A. Tiwari, then a Tamil criminal appeal written by J. Number 15, 2020. Mr. Kalita, then the amicus curiae. In criminal appeal, jail. Number 16 of. Also heard him as lead man, then additional public prosecutor as some. Hearing concludes. Just one.